Good morning, everybody. Happy Super Friday. Welcome to TCF Live. I am Dan Soul. Along with my trusted sidekick, Ellie, we will guide you through the next 3-hour journey through Courtlandia. Starting in Kent County, Michigan, this is Judge Joseph Rossi.
Mr. Sheffield, you're before me because you failed to appear back in April
Yes, sir.
for a status conference.
Yes, sir.
Why didn't you appear back in April?
I became homeless again and started drinking, to be honest with you. And life's just gone downhill since then. So I'm actually glad that I'm here before you today. So I want to get this taken care of and I need to get sober. So
Well, those are certainly great decisions from my perspective. Uh, Here, do you have any idea how much the arrears of child support amounts to in this thing? Like, looks like something over 50 grand.
yeah, over 50 grand. Yeah.
Okay. Yeah, no, that's a chunk of money, and well, and
Yep.
part of the reason I ask is because the statute requires me to set bond at a portion of that.
Yep.
So I'm going to set bond in this time. I'll make it $5,000 cash or surety, and I will reset a status conference to get you back in front of me.
All right.
You'll work on your sobriety, and I know they have some resources to help you with there at the jail.
Yeah.
And when you get back in front of me, we'll talk about what we can do to resolve the case.
Yeah. I did also talk to a friend of the court yesterday. And they've got a program for me when I get out that'll help me get housing and get different assistance through them too. So I was happy to hear that yesterday. So
Very good. Well, I'm open to, any of those plans that you can do. And, when you do classes, meetings or whatever at the jail,
yeah.
get a sign-in sheet or whatever, bring all that. I'll give you credit for it at the time we work the
Okay.
thing out in court.
All right, perfect.
Judge, the new sentence or the new status conference date is going to be July 14th at 1 o'clock.
July
All right.
4th.
So that's our next time we'll see each other will be July 14th.
Okay.
And your attorney should reach out to you prior to that time.
Okay. All right.
Very good. Good
All
luck
right.
to you, sir.
All right. Thank you very much, sir.
All right, Your Honor, we have a Mr. Christopher Harris next.
Thank you.
Do I have the file on Mr. Harris?
This one, Lisa added late yesterday. It was failed to appear for a status conference on April 20th, and Judge Denenfeld's office will just set a new date.
Okay.
And one more thing, do you have a Wilkins in your waiting room?
I do, yes.
Okay, good. Just double. She's going to be immobile. She's been uncooperative. So,
Okay,
all right. So this is Mr. Harris.
thank you. This is the people of the state of Michigan versus Christopher Harris, case number 26-01608-FH, and this hearing is being recorded on Zoom and live streamed on YouTube.
All right, Mr. Harris, my name's Judge Rossi. I'm sitting presiding for Judge Denenfeld this morning, and you're in front of me because you failed to appear for a status conference in front of Judge Denenfeld back in April. Why didn't you appear back then?
Your Honor, I've been arrested for many cases since then. I lost track of the record. I just did 45 days. I'm trying to get on my feet, and it's hard to remember dates when I'm getting arrested for trespassing every day, obstruction of being in doorways. It's been hard, and I'm just trying to get on my feet, Your Honor.
I get it. No,
I hate missing days.
I hear you, and you've been homeless, and that probably contributes to it because, of course, then it's hard to get mail and all the ways we make contact with people to remind them about dates and stuff. So, all right. Well, what Judge Denenfeld asked me to do is simply remand you without bond at this time, awaiting your next status. Did he give us a date for the status conference? His staff, when?
No, they did not. They'll just set it
Okay.
mail notice.
They'll mail notice to you now at the jail, and your attorney. Do you recall who your attorney was when you were in front of Judge Denfeld?
I don't remember. And
Oh, and I don't have your file in front of me right now, but we will contact your attorney as well, and your attorney should reach out to you prior to the status conference so they can discuss what the next steps are with you.
so I'm being reprimanded as in my bond is gone.
Yep, no bond at this time. I'm going to let Judge Denfeld set it. If your attorney wants to bring a bond motion in front of Judge Denfeld before the status conference, I don't know when, he could get you in next week. He could get you in, in a couple of weeks for the next status conference. If it's a period of time, then your attorney can bring a motion and ask Judge Denfeld to set bond. He knows the case way better than I do, obviously.
Over something that happened in April.
Oh, absolutely. Yes. Well, it failed to appear in April, and I don't know what's your underlying charge on this one. Do you know, Mr. Harris?
You said what's my charge on this one?
Yep.
Obstructing, littering, and failure
Well,
to obey.
it's not, yeah, failure to obey a police officer, resist and obstruct arrest. So it's a felony charge that could keep you locked up for a while. That's why you're in the circuit court. So you'll get credit for the time you're in is the only reassurance I can give you, sir. And with that, we're concluded.
Do you have my my lawyer name?
I do not because I don't have your file in front of me, but I will notify them that you're in custody.
Judge,
Thank
it's
you.
Justin McCarthy.
Okay. Yeah, Mr. McCarthy, and he'll reach out to you.
I think that's it for this feed. We are here in the matter of the people of the state of Michigan versus Christina Wilkins, case number 26-03088-FH. And this hearing is being recorded on Zoom and live streamed on YouTube.
All right. You can hear me, Miss Wilkins?
Yes.
And Miss Wilkins, you're in front of me because you failed to appear for a status conference. My understanding is you were too ill at the jail due to some symptoms you were experiencing at the time, and you couldn't appear in person for that status conference. Is that all accurate?
That's right.
Okay. All right. Well, and Wendy, have we set another status conference date?
Judge, this one was actually a bench warrant for a bond violation, not reporting to court services.
Ah, okay. All right. Why did you stop reporting to court services, Miss Wilkins?
I forgot what day it was. I forgot my paper. I lost my paperwork.
All right. Well, I think what I'm going to do at this time is I'm gonna I'll set a bond in your case, $5,000 cash or surety. In the event that you're released, I want you placed on a GPS bracelet. And do we have a new date for, what's our next date for Miss Wilkins, Wendy?
She has a status conference on August 11th at 1.
And I will see you in court on August 11th, 1 p.m. For a status conference.
Okay.
Very good. Good luck to you, ma'am.
Thank you.
Okay, I think I have Mr. Farrell on from the prison. So we can go ahead and do that one.
Oh, hang on. I need to grab, oh, gosh. I'm going to need a minute before Mr. Farrell. So,
Okay. I'm bringing him in, but you can take a minute. Yeah.
Well, the judge takes a minute. Good morning once again, everybody. It is TCF Live. It is Super Friday. It is good to have you all here with me today. I hope you've had a good week. Let's try to finish it off strong. Again, this is Judge Rossi in Kent County, Michigan. Other courts are starting to just come online now, but we'll ride here for a little while longer. Judge is taking longer than a minute. We are a couple minutes in the way back machine, so let me bump us forward here a little. I guess Judge had to go potty or something, huh? There we go. All right, back to Judge.
I'm ready.
Okay, this is the people of the state of Michigan versus Lorenzo Farrell, case number 23-03374-FC, and this hearing is being recorded on Zoom and live streamed on YouTube.
And this matter is before the court today for resentencing. I would invite counsel to place your appearances on the record.
Good morning, Your Honor. Audra Blodgett for the Kent County Prosecutor's Office.
Thank you.
Good morning, Your Honor. Alona Sharon on behalf of Mr. Farrell, who is present via Zoom video conferencing, and that is without objection, Your Honor.
Very good. Thank you, Ms. Sharon. And Mr. Farrell, I am going to need to swear you in and have you speak. Can you unmute the audio on your system?
Are we good?
Yep, I can hear you, sir. If you would raise your right hand, please. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes, I swear.
Very good. And Mr. Farrell, it's acceptable to you to be resentenced today via Zoom video as opposed to in person and in the courtroom?
Yes.
All right. And have you had the opportunity to read and review the pre-sentence investigation report that was prepared in this matter?
Yes, I have.
And you've also had the opportunity to talk over the contents of the report with your attorney?
Yes.
All right. And Ms. Sharon, are there any changes, additions, or corrections that need to be made to the PSI at this time?
Your Honor, so just so it's clear for the court, the PSI that I reviewed with Mr. Farrell that was provided to us, it appears to be the exact same PSI as from when he was sentenced. There's just an updated case report that came along with it. But I do think at this point, the PSI should be corrected to reflect my name as the attorney as opposed to Ms. Paletta at this point. So there's several places where that correction would be made. And then also the jail credit is corrected on the case report, but not within the body of the PSI. So the number provided for credit in the updated case report is accurate. And of course, my eyes are not, 1,247. We have no objection to that date, but I guess I would just ask if the PSI be updated to include that updated number of credit.
Okay. Certainly, we can make the correction regarding your name as counsel. And then second, we can also update the PSI to reflect the accurate amount of jail credit.
And the only other factual correction, Your Honor, is in Mr. Farrell's criminal history. It would be box 4 of 7 in the criminal history. And it's a criminal sexual conduct 4th degree with an offense date of 9/30/2022. And it reads as open/pending. That case was nolle prost, Your Honor.
Okay, it's 4 of 7. Any objection to that change in the PSI, Ms. Blodgett?
I am looking at that right now, Your Honor, and I just want to double check our system to make sure that that is correct. I have no doubt that Ms. Sharon is representing it correctly, but just as a double check. Yes, I do see that in our system, and I have no objection to the change.
Very good. Then I will change that to make the criminal history accurate. Very good. Are those the entirety of the corrections to the PSI from your perspective, Ms. Sharon?
Yes, Your Honor. Thank you.
All right. And Ms. Blodgett, do you have any changes, additions, or corrections to the PSI at this time?
No, Your Honor.
I did note, Ms. Blodgett, that the PSI writer indicated that the guidelines that were recalculated or calculated on count one of 81 to 168 months didn't take into effect the prior offense because of limitations within the guideline scoring systems. Do you have any more information on that?
I don't, Your Honor, but I do know that count one is subject to the 25-year mandatory minimum. So I took those guidelines with a bit of a grain of salt, so to say, because we will be arguing, and it's our position that that 25-year mandatory minimum applies, and that's the sentence we would ask for, which is outside of those scored guidelines.
Understandable. Okay. Any insight from you on the guidelines issue, Ms. Sharon?
No, Your Honor, when I read that language, when I reviewed it with Mr. Farrell, I also candidly told him I had no idea what that meant. But I agree with Ms. Blodgett. It's a 25-year mandatory minimum. So to the extent that the guideline range falls below the 25-year mandatory minimum, they're pretty much irrelevant, as you know, because Your Honor obviously has no discretion. You must impose the 25-year mandatory minimum.
Nope, that appears to be fair assessment. But since we're talking about the what's applicable here, is this a case where I can or am required to sentence consecutively, or does the presumption of a concurrent sentence apply? I'll give you the first stab at that one, Ms. Sharon.
So certainly, Your Honor, there's absolutely no authority for mandatory consecutive sentences. As it relates to discretionary consecutive sentences, the only time the court can impose a discretionary consecutive sentence is if the two charges arise out of the same transaction. That's the standard from the statute. And our case law tells us that arising out of the same transaction means that the two counts would have to happen at the same date, place, and time, right? The fact that there may be a pattern of sexual assaults is not enough to arise out of the same transaction. They have to be at the same date, place, and time. I reviewed my notes from the trial, from reading the transcripts the other day when Mr. Farrell and I met. And looking at the complainant's testimony, there really isn't, as it is with a lot of young complainants, a lot of detail as it relates to when different events happened. It's more, oh, this happened one time, this happened one time, this happened one time. And where the record is vague as to date, place, and time, it would be impossible for the court to come to the conclusion that they arose out of the same transaction. And without being able to make that finding, Your Honor, the court would not have authority to impose consecutive sentence.
Okay. All right. And Ms. Blodgett, what's your position on consecutive sentences, if it's any different?
No, I agree with Ms. Sharon on the law, Your Honor, and I also reviewed the transcript, and unfortunately the victim's testimony is a bit vague. I'm sure Your Honor remembers the difficulty he had with testifying. I would largely defer to Your Honor's memory of the trial, as neither one of us were present for that, but wasn't able to independently pinpoint any exact testimony from the victim that these two assaults happened during the same transaction. I do know there might be some support for an argument in the YWCA report and the victim's mother's disclosure, but again, I'm not positive that that would be enough to get us there, but I would defer to the court.
Okay. All right. No, thank you. Okay. Any other discussion we need to have regarding the pre-sentence investigation or the guidelines at this time? Ms. Blodgett?
No, Your Honor, nothing from the people. Just for the record, the victim was notified of today's proceedings and that it would be happening, but our office has not received any written or other statement.
Okay. All right. That's I'm glad you noted that at this point. Okay. All right. Well, let's move on then to elocution and Ms. Sharon.
Yes, Your Honor. Mr. Farrell is, I think there's no secret to the court that Mr. Farrell maintains his innocent, which is his right to do so. He's obviously in the middle of pursuing his direct appeal in this matter. It's, the court is supposed to consider Mr. Farrell as he is today, not at the original sentencing. And so therefore, information about his incarceration should always be relevant at a resentencing. Your Honor, he is currently housed at level 2 safety level, which is the lowest level he would be eligible for because he was serving a life without parole sentence. So that should indicate to the court that his conduct and behavior since his incarceration has been good and that the prison does not view him as a risk to the safety of the facility or to the officers. Your Honor, because of the length of his sentence, he has not been eligible for programming. I saw Your Honor nodding a bit, so I don't know how familiar the court is with MDOC, but obviously the longer the sentence, the longer the wait is to be involved and engage in programming. He is on a wait list to get a job. There's always more prisoners than there are jobs available. But Your Honor, that's really all I have to update the court in terms of where Mr. Farrell is at. Mr. Farrell is raising his hand. I'm not sure what he wants to say. Mr. Farrell?
Yes, I am applying to go to college. Well,
Oh, yeah. I apologize. He does have his GED, Your Honor, and he is trying to get into college classes as well.
I'm machine certification as well, and apply for certificates prior.
Good. No, I certainly don't have any objection whatsoever to you participating in any programming that you're eligible for, and particularly, Mr. Farrell, because I'm, resentencing you here, not to a situation where, you'll be dying in prison, but rather where at some point you will be released from the MDOC. I think the idea of participating in whatever programming you can is excellent. Anything additional you would like to say before I resentence you, Mr. Farrell?
No, sir.
All right. And Ms. Blodgett, is there any comment from prosecutor's office?
Only to reiterate Ms. Prevet's comments from the original sentencing that although defendant may not present a danger to the prison population and adults, this is his second sexual penetration of a minor. We have a 3-year-old and an 8-year-old. So I would just encourage the court to take into consideration the extreme circumstances of this case and defendant's criminal history.
No, and those are a concern, and my same concerns that I expressed when I imposed the original life without parole sentence is that, Mr. Farrell presents, as a well-spoken, handsome man, and in both of the convictions, there were situations where he became involved in a romantic relationship with the mother of the child, and then subsequently utilize that access to the child to commit the sexual offense. And I am very concerned about that being a risk in the future. However, the law does not allow me to because the case was not originally charged as a life without parole case, the law doesn't allow me to impose that sentence, and therefore I agreed that resentencing is appropriate in this matter. Count 1 is criminal sexual conduct in the first degree. Victim is under 13, while Mr. Farrell was older than 17. It is enhanced as a second or greater felony, and the sentence of the court in that case then will be 25 to 50 years in the Michigan Department of Corrections. Count 3 is criminal sexual conduct in the second degree, and I'll note the guidelines on count 1 were calculated by the Department of Corrections at 81 to 168. However, the circumstances of the offense make it a statutory mandatory minimum of 25 years. That's where I came up with a 25-year minimum sentence. And then count 2 as criminal sexual conduct in the second degree. Same circumstances, victim under 13, Mr. Farrell, 17 or older. Guidelines.
Your Honor,
yes.
I don't mean to interrupt you, but I don't think that Your Honor is intending to resentence him on that count. It's only that first count of CSC 1 that needs to be resentenced.
That's true, and the presumption of concurrent sentencing would apply because I think I sentenced concurrently the first time. Is that accurate?
Yes.
Okay, very well. Then I'll go with the same sentence I imposed. Right, I won't resentence on count 3. That's 96 to 180 months to be served concurrently. And I will note, as counsel accurately mentioned and MDOC has noted here, there are 1,247 days of jail credit to be applied. Yeah, and then there's also a requirement in this case for lifetime electronic monitoring imposed by Michigan statute upon Mr. Farrell's release on parole. He is to be electronically monitored pursuant to the MDOC's case management program, and of course mandatory registration on the sexual offenders registry as well.
Your Honor, if I may just make a record of something.
Yes.
I'm sure that Your Honor is going to advise Mr. Farrell of his appellate rights. I do just want to place on the record that today's Friday, on either Tuesday or Wednesday, I believe, I did mail to Mr. Farrell the notice of appellate rights and the request for counsel. He and I don't believe he's received it yet, but he and I did review what he needs to do with that form. I provided him with instructions, and I will follow up with him to make sure that he receives, that he actually does receive the form, and that he's able to send it in if he does want to file an appeal off of this new sentence, Your Honor. But I would ask the court to still advise him of his rights. I just wanted to make the record that the form has been sent to him.
Very good. No, and Mr. Farrell, I will therefore advise you that this is, because I have resentenced you today, operates as a final judgment of the court. It triggers important dates for your appellate rights, and I will assure that you have a lawyer appointed to represent you on appeal if you would like to appeal my decision today, but can't afford to hire your own attorney. It may be Ms. Sharon, it could be a different attorney. I'll leave that up to our appellate defender's office and assignment system. But Ms. Sharon has indicated she has already submitted to you a form advising you those rights and the information you need to provide in order to be appointed counsel. There's some information about your financial wherewithal, etc. And I will advise you that you do need to fill out and return that form no later than 6 months from today's date if you wish to appeal my decision today. And given the ongoing nature of the appeal in this case, I would certainly advise you to return it as soon as you can.
Your Honor, if I may, he really should return the form within 42 days.
Well, 42 days. I stand corrected, and Ms. Sharon probably knows the deadline even better than I do. So 42 days, Mr. Farrell.
Yes, sir. Can I make a comment, address the court concerning court costs and restitutions?
You know, did I impose? Yes, no, I do I need to reimpose those at this time, Ms. Sharon, or do they just stand from the prior case?
I believe that they should probably be listed on the new judgment of sentence, Your Honor. If you can give me 1 second, I'll try and bring up the previous judgment of sentence on my computer.
Question the court, can they be suspended? There's financial ability is at zero. And cost of living, they just raised the prices of everything in prison as well, 47 items. And just for medical is $5 just to see medical, and I don't have financial gainful financial support or a job.
Your Honor, just for the record, on the original judgment of sentence, I'm seeing a state minimum cost of 136, crime victims 130, and court costs of 1,000. That's all I see on the judgment of sentence. I don't see any restitution, and I don't have a recollection of restitution being ordered. Ms. Blodgett, do you?
Reviewing now.
Yeah, Miss Sharon, there was no restitution. You were correct on the assessments on the costs.
Okay,
That's
yeah,
what-
please, those would be the costs that were imposed at the original sentencing.
All right, and so those costs are going to remain the same. They include $1,000 in court costs, $204 in state minimum cost, and $130 crime victim right assessment on both of the. I'm sorry, on count one, and then count two also is $1,000 in court costs, $68 state minimum cost, $130 crime victim right assessment. And the question by Mr. Farrell is, can I suspend those? And the answer is, unfortunately, no. I cannot suspend payment while you're incarcerated. I have to begin taking those out of any wage you do earn at a prison employment. It is controlled by statute. You're allowed to retain a certain amount of that money for your own expenditures. And I do sympathize with the fact that I'm sure the commissary items, et cetera, are going up in cost along with all other costs, it seems, in the community. But I'm also required by statute to impose those costs and to collect them out of any wage that you earn while you are in prison. So I'll have to deny your request for suspension of collection of the court costs at this time. And with that, I believe we are concluded.
Thank you very much, Your Honor.
Good morning once again, everybody. TCF Live on a Super Friday. Curious what you think. Let me know in the chat. So these people are working in the jail for pennies in order to buy like a $5 bottle of Coca-Cola. Is it fair to take that money away from them? I don't have a personal opinion on it. I could go either way, but I'm curious to know what you think, so let me know in the chat. In the meantime, let's go to Missaukee County. Judge Elmore, again, appearing from Missaukee with a spiffy new camera angle, so that's fun.
All set over there. All right, folks, good morning. We are on the record today now for 28th Circuit Court here in Missaukee County. And we begin today's docket call by taking up the case of People of the State of Michigan versus Andrea Bloss. File number here is 25-3607. FH. Appearances, please.
Speaking of David Denham on behalf of the people. May Police Court Rep Champion appearing on behalf of Ms. Bloss. Ms. Bloss is seated to my left, Your Honor.
Thank you. Also here before the court this morning is Ms. Laura Odell. She's the agent from the Michigan Department of Corrections, serving as the probation officer here. One moment. We're here today for a probation violation hearing. We were last on the record on this file. Looks like back on April 17th. The court allowed the defendant to appear via Zoom for an arraignment. There was a requested warrant for a probation violation filed back on March 19th of this year. It included 5 allegations. What are we doing today, Mr. Champion?
Your Honor, my client will be entering the plea to the violation, Your Honor.
Thank you. Is there any agreement, reduction, anything else like that I need to be made aware of, Mr. Denon?
Not as part of the plea.
Yeah. All right, thank you. Ms. Bloss, is that how you wish to resolve this today?
Yes, sir.
Please raise your right hand, ma'am. Do you swear or affirm that the information, testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may lower your hand. So, Ms. Bloss, if you admit guilt of these 5 violations, they aren't new criminal convictions. They are just probation violations. If you do so, and I accept that plea, you'll be given up the right to have a contested hearing and make the prosecutor prove the allegations by a preponderance of the evidence. You also will be given up the right to question and cross-examine any witnesses against you, as well as the right to present witnesses, evidence, or testimony if you chose, as well as the right to remain silent and not have that silence used against you. And if the court accepts that plea, you'll be resentenced on your original offense. In this case, you were originally convicted of possession of a narcotic or cocaine in an amount less than 25 grams as a second habitual felony offender. That makes the maximum potential punishment up to 6 years and up to, $50,000. Well, nobody gets $50,000, but anyways, that's the punishment. And actually it would be up to $37,500. All right. Is that what, do you understand?
Yes, sir.
All right. Have you had time to speak about this with Mr. Champion?
Yes, sir.
And has he been able and available to you to answer all your questions?
Yes.
All right. And are you satisfied with his advice at this time?
Yes.
All right. There are 5 counts. Do you need me to go over those again with you?
No, sir.
As to the 5 counts that appear on the request and warrant, how do you plead?
Guilty.
Before the court can accept that plea, I'm going to have you tell me what it is that you did that makes you guilty of those allegations. Now, before I do, have we already removed, was there a delay removal before? Or is she still on the delay?
She's still on the delay, Your Honor.
Copied it. Thank you. I forgot to mention this. And so I'll go back. If you enter a plea of guilty and the court finds you guilty, you could lose the benefit of that delay that you had previously. Do you understand? All right. And let me take just a quick look. You were placed on a delay by this court on December 1st of 2025. What were the terms of that delay, Mr. Champion or Mr. Denham? What was the benefit to receive? Was it dismissal? I mean, I know it wasn't under 7411, so. Does anybody recall its price should be on the PSI? Miss Odell might find that. No. Anything, Miss Odell?
There was no pillow agreement, Your Honor. It just looks like it was to give her the opportunity to attend treatment.
That's what I thought I recalled. But all right. So, ma'am, you can lose the benefit and the conviction could become permanent. Do you understand? Do you still wish to proceed with the guilty plea? The court begins the factual determination by taking judicial notice of the order delaying offenses, which is contained in the court's file, was signed by me on December 12th of 2025 and subsequently acknowledged by the defendant, Ms. Bloss. So, Ms. Bloss, count 1 here alleges that you violated your probation by violating condition 2.8 to complete outpatient or residential treatment, and alleges you failed to complete the outpatient treatment after being referred to it by your agent. Is that correct? Tell me about that. What happened?
Well, I thought I was ready to do it on my own, and I was not.
Were you in a program?
I was in outpatient, yes. I stopped going, but I'm back in that program now.
So
transportation, I'm not gonna make excuses, but just all the things that come with living on your own.
How long were you away from that treatment? In other words, how long when you stopped to when you can initiate the fatigue?
It's been a couple of months, because then I got myself back into treatment.
As to count 2, allegation of violating condition 4.19 to have no contact with the Department of Corrections inmate without permission. It says here that you had an ongoing contact with Anthony Prentice, who was an inmate of the Department of Corrections. Is that true?
Yes, sir. We had a couple of phone conversations.
Right. Now, if I remember right, Mr. Prentice and you were in a dating relationship at some time,
Yeah, at one point, yes.
and at one point were you both at a treatment program or something together?
Yes.
All right. And you knew you weren't to have any communication with Mr. Prentice, at least without asking your probation officer?
Yes.
Thank you. Count 3 alleges that you violated condition 4.22 that required you to comply with the written and verbal orders of your field agent. And more specifically, it says that you failed to comply with the orders by having continued contact with Thurston Kenonen, Keinonen. Is that right?
Yes.
Who was this individual?
He was staying at a house that I visited, I guess, and it's a long story, but we don't talk anymore. I barely talked to him then. I met him and it was just the wrong place, wrong time, and it's not somebody I know.
All right. Why? What was the connection for? What was the purpose?
He was the brother of a friend of mine.
Okay. But your probation agent told you to have no contact with the individual.
Correct. I did not know he was on parole or anything at the time, so.
Count 4 alleges that you violated condition 4.25 to report any arrest or police contact within 24 hours. And it says here that you allegedly failed to report a change of address and change of employment status. So what I should have said is report any arrest, police contact, change of residence, or loss of employment to your agent within 24 hours. Tell me, did you lose his address? Did you move? Did you change an address, change a job?
I'm sorry, what was
That's okay. Did you move?
I moved, yes, and then I got a new job.
Okay. And how long was it before you told your agent?
It had been a couple of weeks, I believe. Because I was working at a factory and then I moved and then I got a job at a hotel and I didn't even think to, didn't even think to mention that. It was just, I just switched. I just got a new job.
Okay. As to count 5, it alleges you violated condition 4.22 again by failing to comply with the written and verbal orders of your agent. In this one, it says you failed to report as instructed and scheduled on March 18th of this year. Is that correct?
Yes, sir.
Why did you fail to report?
Again, I moved too far away in just transportation and it was just, yeah. Things were slowly starting to slip from me, so that's why I just reeled it back in. And
all right. Mr. Denhout, you believe she provided a factual basis?
Yes.
Are you aware of any other promises, threats, inducements?
No, Your Honor.
All right, Mr. Champion, you agree?
I do, Your Honor.
I'm going to note here that technically it's not a probation violation hearing because technically it's a hearing for sentencing because it's a review of a delay of sentence, which is somewhat different. All right. The court finds the defendant in violation in terms of the conditions of her delay of sentence. We have called it a probation violation, as I just mentioned, but technically it's a review of the delay. Therefore, the court finds the defendant guilty of those 5 allegations. The next question is proceeding to sentencing. Are we able to proceed with sentencing now, Miss Odell?
Yes, sure.
Any objection, Mr. Denon?
No.
Same question, Mr. Champion?
No objection, Your Honor.
Back to you, Miss Odell. And if you have a copy of that PSI, I would like to see it. But let me make sure I don't have one here. Yeah, I remember reading one this morning.
Would you like a recommendation before or after you review the PSI?
Before is fine. I'll make some notes and then you can give it to me and I'll look at it.
April?
Oh, yeah, or I'll take it out. All right, thank you. Miss Odell, up to you.
Your Honor, these violations of the delay occurred back in March, as noted. Since that time, Ms. Bloss did enter back into residential treatment. She was there from March 30th of this year to May 15th of this year. She then entered into a sober living facility where she remains still there. I did receive a letter verifying that she's continuing in treatment. Outpatient treatment, meeting with a therapist. She also provided meeting proof that she's working full-time at the Fairfield Inn in Traverse City. She was definitely slipping back in March, but she's absolutely gotten herself back on track as of today, and I don't want to derail that progress. So at this point, I would recommend that we continue supervising her and impose 40 hours of community service work.
All right, thank you. Mr. Dunham.
Your Honor, certainly we defer to a large extent to Mrs. Odell's recommendation. She has that insight in terms of what's going on in this case. Certainly there's been a lot of starts and stops. Looking at Ms. Bloss this morning, she certainly looks healthy, and that's a very positive, I think, reflection of the work that she's done. She did receive a significant benefit, or the original recommendation, as the court will note, was 240 days. Which was suspended to allow her to go into treatment. Again, there's been several stops and starts, but the people are certainly supportive of giving Ms. Bloss one last opportunity to continue with her rehabilitation, and hopefully going forward there won't be any, I guess, more issues. But we do support the recommendation, Your Honor.
All right, Mr. Champion.
As the court's aware, Your Honor, when we're dealing with addictions, it's a very ugly animal. Typically, a person will fail about 9 times before they become sober. Ms. Bloss was honest with the court, saying that she recognized back in March that she was slipping back into the old patterns. She is now doing a wonderful job. She's very proud of what she's accomplished. I would ask the court to follow the recommendation in this situation.
What is the credit that she has? Jail credit. I know before she had 0, but
She had 0, Your Honor, because of her parole status at the time.
Yeah.
So it's currently 0.
all right, still 0. All right, thank you. Ms. Bloss, everyone else is saying give you a second chance. I'm going to be very honest. It's up to you now to convince me not to put you in jail for 365 days. Tell me why I don't do that, because I gave you opportunities. I gave you orders. You ignored them. So I'm ready to send you back to the jail and have you sit there for a year. You tell me why I don't do that, because right now that's where I'm leaning.
Honestly, Your Honor, what's different at this time is I've never been able to recognize my behaviors or my patterns, and I just allowed my addiction to completely take over and ruin my life. This time I was able to notice, like, okay, you have to stop. Like, I was able to reel it in, and I noticed that very quickly. I am so proud of like the work I have done. I've done a lot of internal work. I've discovered a lot of things about myself. I'm working with a sponsor regularly. I'm actually working the steps of a program this time, which I've never done before. I stayed 45 days in treatment. That's the longest I've ever stayed, and it was definitely needed. I learned a lot about cognitive behavioral therapy, which I didn't know anything about. And I realized I have a mental, it's not just an addiction, it's mental as well. And I've discovered a lot of things about myself these past few months, and I put in a lot of work. I'm working. And
What days a week do you work?
Huh?
What days of the week do you work?
I work Monday through, I have Mondays off because that's the meetings, the house meetings of the house I'm at. I work Tuesday, Wednesday. I work 5 days, 6 days a week sometimes.
All right.
I'm moving up very quickly in that job. I work the front desk. I just received a praise from my boss about how well I'm doing. I'm proud of the work that I've been putting in, and I am a completely different person in front of you today than I was a while back. I put in so much work. I have so many things to look for. My daughter is getting married, and she wants me to very much be a part of that, and that's very exciting. This is where it stops, and I firmly believe that now. This is where this is what it took. It took those 45 days in Bear River to learn a lot of things about myself. I'm not seeing anybody. I'm not in a relationship, and this is the first time that I've really focused on just me. And I was just able to pay my rent for the first time, which is huge for me. I'm really just proud of where I am right now. And I want the chance so badly to continue working on me, because I can be a success story. I really can.
Thank you. You may. I'm going to do it this way for a very, very obvious reason. I'm going to continue the delay of sentence. Why? If I find you guilty, and I'm sorry, if I did find you guilty, but if I violate you and take away the benefit of the delay, I really should be giving you 60 days. I don't want to interrupt your treatment program, but I'm going to tell you, I don't care what the violation is. If it's a speeding ticket, I will send you to the jail for either 365 or I'll send you to prison. So
Well,
if I take away the delay, I'm going to put you in the jail now. If I put you on probation, let's say I only gave you 2 months and I put you on probation, you violate. Well, the legislators say I can only give you 15 days, maybe. So I don't want that. I want that if you violate anything, I'm not limited to a sliding scale. I get to finally sentence you. And when I do, there's a very, very, very high likelihood that you will not go home. You will walk out of here through that door behind you with one of the officers.
yes, sir.
And you won't see your friends and family other than through a pane of glass talking on a telephone for at least a year. Which means I'll likely put you I don't put you to prison. So I'm going to continue the delay. And we'll add to that delay a term of community service. And what did you say, Ms. Adele? What was your 40 hours?
40 hours.
I'll add to that term or condition of the delay 40 hours. So the keys to the jail or prison cell are now in your hands. You do not want to come back here. Well, you actually have to come back so I can finalize the sentence later on. But you have to come. You do not want to come back here in the situation in which you're in now, because you will not leave through that door. You will leave through that one.
Yes, sir.
All right. So, because the sentence is still in delay, I don't need to do any appellate rights. Anything further, Ms. Odell?
No, Your Honor, thank you.
Mr. Denham?
No, Your Honor, thank you.
Mr. Champion?
No, Your Honor.
Ms. Bloss? I think I've made it very clear. Do you agree?
I absolutely agree.
All right.
Thank you.
Not mess this up.
I won't. Thank you.
Yes, ma'am. We're adjourned. Why she's running away? All right, thank you.
Alrighty, friends, it is still hour 1 of TCF Live on this Super Friday. Let's go to Florida, do our daily check-in with Wade Mercer.
Christopher Landry, unless you need to take somebody else.
No, sir.
Christopher Landry. Mr. Landry, come on up. Mr. Landry, good morning. Mr. Landry, you're here because you've been accused of violating the terms of your state probation. I've got a copy of the warrant in front of me signed by Judge Garcia. It's a no bond warrant. Mr. Landry, we're going to get you a lawyer appointed this morning if that's what you would like, sir. And then Mr. Blunt's going to give you a court date and we'll see if you have any questions. Mr. Landry, would you like to have an attorney appointed to represent you?
Yes, sir.
I'm going to appoint the Public Defender's Office of the 14th Circuit to represent you. Listen to Mr. Blunt, and we'll see if you have any questions in just a minute.
Your Honor, we acknowledge receipt the affidavit, waive form of reading in or denials to the allegation he violated terms and conditions of his probation, set him for court on July 9th. And we've already had a meeting on all the VOPs thus far. The cutoff is Monday, so we're going to work him in and try to come see him between now and the night.
Yes. Thank you, Mr. Blunt. Ms. Harris, anything from the state?
No, Your Honor.
Thank you. Mr. Landry, do you have any questions?
No, sir.
Have a good day, Mr. Landry. We have Alicia Everett. Miss Everett, good morning, ma'am. You're here because you've been accused of 1 count of driving with no valid driver's license. Miss Everett, I've read the complaint. There is probable cause, but it looks to me like you have no prior history. Is that right, Miss Everett?
Yes, sir.
Miss Everett, I'm going to appoint the Public Defender's Office to represent you for first appearance purposes. Please listen to Mr. Blunt, ma'am.
Your Honor, at this time, Ms. Everett would withdraw any previously entered pleas of not guilty and or plea of no contest to the charge of no valid driver's license, a second degree misdemeanor, punishable up to 60 days in jail, and a $500 fine. Agreed upon sentence with the state, subject to your honor's approval, is that she be sentenced to pay a $400 fine within the next 60 days, with the understanding failing to do so would result in a 10-day jail sentence with credit for the 1 day she has served.
Thank you, Mr. Blunt. Ms. Harris, is that agreeable with the state?
It is, Your Honor.
Thank you. So, Ms. Everett, the plan is for no one wants you to do the 10 days in jail. I put that on there just to, first of all, just to keep people, remind them this is serious. I want you to get it taken care of. You'll also be given a court date, ma'am. The reason for the court date is sometimes you can't get it paid within the time period. Something comes up or you just simply can't do it. You come in on the court date and say, Judge, I wasn't able to get it paid. I need 2 more weeks. I got half of it paid, or I got 3/4 of it paid, or whatever the circumstances are. So the court date that I'm about to give you is only if you need it. If you get it paid within the 60 days, you do not come back to court. Ms. Everett, do you have any questions about that agreement?
No, sir.
Is that the plea you would like to enter, ma'am?
Yes, sir.
Ms. Everett, I'm going to accept your plea of no contest to the charge of driving with no valid driver's license. I'm going to withhold adjudication of guilt. Listen carefully. I'm going to sentence you to 10 days in jail, but you will never serve that 10 days as long as you pay the court costs and fines. Ms. Everett, the court costs and fines are $400. They're due by August 26th. Ms. Everett, if you get a new driver's license by that court date, I'm going to knock $100 off that court costs and fines, because I would rather you spend that $100 getting a license than I would you just paying court costs and fines. So if you show up with a driver's license to the clerk's office on or before the 26th of August, you'll only pay $300, not $400. Ms. Everett, as I mentioned earlier, if you can't get it paid by the 26th of August, you need to be in the county courtroom on August 27th at 8:30 to ask for an extension. I'll listen to you and we'll go from there. If you don't pay it and you don't show up for that court date, there will be a warrant issued for your arrest, Ms. Everett. So make sure you either pay it or come to court and ask for an extension. Ms. Everett, they're going to process you out this morning. Going to be released this morning. They're going to give you this paperwork that I just signed, ma'am, before you leave the jail. Just take care of it by the 26th or come back to court on the 27th. Do you have any questions?
No, sir.
Have a good day, Miss Everett.
You too. Thank you.
Yes, ma'am. Gregory McDonald. Mr. McDonald, good morning. Mr. McDonald, you're here for first appearance with 1 count of trespassing. You're also accused of 1 count of possession. The jail sheet says possession with intent to sell. Let me see.
Judge,
I'm not sure that's correct. I'm not sure that's correct. Give me just a second.
Your Honor.
See. Yes, sir.
So it's the jail sheet says that because if the court will look at I'll draw the court's attention to page 3 or 4 of the arrest affidavit. On the front of that, it says statute description, possession with intent to sell, manufacture, to deliver a controlled substance, schedule 1 on the front page of the arrest report. However, when the court looks at the body, which is why the confusion, it just said there was 1 clear plastic baggie containing 1.9 grams located. So I think that's the discrepancy. The cover sheet page of the affidavit says with intent. However, the body of the affidavit, it does not give the elements that would meet probable cause for an intent.
Thank you. Ms. Harris, do you agree there's no probable cause on the intent to sell portion?
Yes, Your Honor.
Okay, so I'm going to find probable cause for possession only. Ms. Harris, I'm going to ask you to notify the officer that of the issues. And the other issue I'd like for him to try to do, well, he does it in this case. A lot of times when they charge trespassing, they don't clarify which subsection, but this officer does it. He just doesn't use the subsection on the drug portion. So if they'll put the subsection in there and make sure the front and back match, that would be helpful. So there's no evidence of intent to sell, Mr. McDonald. There is evidence of simple possession, which is the same thing you had before when you went to prison, according to the Department of Corrections website. I did see that. So there's probable cause for that 3rd-degree felony, not the 2nd-degree felony. It looks like you got out of prison in July of 25. So I'm going to set you a bond, but I'm going to listen to the attorneys before I do so. Ms. Harris, anything from the state?
The state would just ask for a condition of random UAs and no contact with the victim of the trespass.
Thank you. And Mr. Blunt?
Your Honor, I am getting a little older and I'm kind of losing some of my memory, but I would ask for a lower bond in this case just because it says that they were called in for a trespass. So I know there are the reason I'm saying all this is that I can remember there's certain misdemeanors that had to be committed in the presence. I know it was found in the close proximity, but I'm just asking for a lower bond because I think this may be a right motion on this case that may yield a favorable result for my client. So I would ask for a lower bond with the understanding that I don't think this was, and the court, I have no problem with the court or the state put me in my place, but I know there are certain misdemeanors that have to be committed in the presence of law enforcement, and if they're not, it's essentially a warrant has to be sought to arrest on. And I know y'all may have been dealing with this later, but I just asked the court to take that in consideration that this may be right for an upcoming motion. So with that considered, set a lower bond for my client.
Thank you. Mr. Blunt, you may be right. Let me take a look at that. I did not look at that issue at all this morning. But I don't know that trespass is a warrantless arrest. And if it's not, anything found after the arrest may be inadmissible. So let's look at the warrantless arrest statute, but you may be exactly right. Mr. McDaniel always looks at that, and I a lot of times I forget to look at that issue, but let's look at it. Ms. Harrison, I'll hear from you once I look at the statute. I think it's in 901 maybe.
Mr. McDaniel is way more efficient than me in the mornings.
He does a good job, especially on this issue, and I don't. So we're gonna see what it says. I think it's 901. The problem is, the confusion is that 901.15 is a statute in Florida that says when an arrest without a warrant is lawful, but some other statutes have it in the statute. For instance, retail theft, it's not in 901.15, but it's in the retail theft statutes. I don't think it's in the trespassing statute itself. So here, where it lists the misdemeanors you can arrest for without a warrant, battery, criminal mischief, racing, exposure of sexual organs, trespass on school grounds, but not regular trespass. So it appears that regular trespass is not something you can make an arrest for, at least not under that statute. So let me go real quick. It won't take just a second to do it right. Look at the trespass statute, make sure it's not in there. Don't think it is. Trespass statute is 810.09. It's a pretty long statute, but I don't see in here where law enforcement can arrest for trespass not occurring in their presence. It's not in there. So then the question is, did this trespass occur in the officer's presence? And the way I read the complaint, it didn't. He's on the sidewalk somewhere, but the officer asked him, did you go on this property? And why would he ask him that if he was still there at the time? So he must have been on the sidewalk somewhere else away from the property. So Ms. Harris, what's your position on bond or release or ROR, ma'am?
Your Honor, I agree that right off the bat, I don't see where the officer could arrest unless the trespass was in his presence. You know, maybe we find out that he could in some situation, but at this time, I don't see where he could. So I would just defer to the court on that issue.
Thank you, ma'am. So, Mr. Blunt, I think you're right. So if the trespass didn't occur in the officer's presence, which it doesn't appear it did, and he didn't have lawful authority to make an arrest, he could charge him, he just couldn't arrest him. But then the drugs were found solely as a result of the arrest, allegedly, Mr. Blunt, is that right?
That's And it's to me, reading the affidavit, I was confused as to whether my client was at the Piggly Wiggly when he stopped. However, it says en route. And if he was not at the Piggly Wiggly, he was asked after Miranda if he was on the above location property, and he advised me that he was. So he wouldn't have been asking if he was still there. So with that being said, he could have took his information, but not arrested him then, and arrested him and charged him at a later date. That would have been proper procedure. Therefore, the arrest wouldn't have happened. Therefore, it's fruit of the poisonous tree, and it trickled down, Judge. This is my argument this morning.
Ms. Harris, any response?
No, Your Honor, nothing further.
Mr. McDonald, I think that's a pretty good argument. We'll let Judge Garcia sort it out in felony court, but Mr. Blunt has Mr. McDaniel, that normally covers first appearance, has done a really good job also. The case law he's provided me says that when they're responding to serve these trespass warnings, they're acting as an agent of the owner of the property. So in this case, it's a little different because they're not serving a trespass warning, but it's still a helpful analysis. So I think what I've got to do is give you the benefit of the doubt. It appears there's a strong argument that the arrest may be questionable, and we'll let them figure that out in circuit court. What I'm going to do in this case is, despite your prior history, I think the appropriate thing to do is give you an ROR, because there's certainly, the officer may have exceeded his or her authority in making an arrest for a trespass that did not occur in her presence. So I'm going to give you an ROR. That means you're going to be released on your own recognizance. The only condition of your ROR is no new law violations. Okay, that's the only condition. If you get accused of a crime while this case is pending, that would violate the ROR, and you could go to jail with no bond. You're not on conditional release. You're not on bond. You're going to be released. I am going to ask the jail to give you a notice for your court date, which I'm going to give you in just a second. But I think that's probably the appropriate thing to do this is one of those rare cases where it looks like the search was solely the result of an arrest, and that arrest potentially may not be authorized by Florida law. So given all that, what court date are we looking at, Madam Clerk?
July 7th. Yeah. Oh, I'm sorry.
Mr. Blunt, July 7th. July 7th, the jail's going to give you notice for July 7th. No new law violations. Mr. McDonald. Mr. McDonald, I'm going to add a second condition of that. Judge Garcia requests a condition of random urinalysis. So I think it's probable cause for a crime. I just don't know that it was a lawful arrest. We're going to add a condition of random urinalysis. So be aware of that. Judge Garcia very well may have you drug tested when you come to court, Mr. McDonald. Be aware of that possibility, and that could revoke your ROR and result in a bond or no bond if you have something in your system you shouldn't have or you don't have a prescription for. Mr. McDonald, you'll be released this morning. Just make sure you show up at that court date. The jail will give you that notice. Do you have any questions, sir?
No, sir.
Mr. Blunt, anything else?
No, sir. Thank you, Your Honor.
Yes, sir. Ms. Harris, anything else in this case?
No, Your Honor.
Yes, sir.
So I've got ROR with random urinalysis and no new law violations. Thank you. We have Lionel Crawford next. Mr. Crawford, good morning. Mr. Crawford, you're here because you've been accused of aggravated battery on a person in prison or jail. Mr. Crawford, there is probable cause in the complaint. I don't have the complaint. The jail's going to be bringing it up here. It was not included in the first appearance packet. So when I called Sergeant Campbell, he emailed it to me. I know you've got to have the original, so they'll be getting that to you. So there is probable cause for that offense. I know that you're already there on a pretty sizable bond. I also know you have a hold from the U.S. Marshal Service. So I'm going to set your bond in this case. I think you're entitled to it, but I'm going to listen to the attorneys before I do that. Mr. Blunt, anything on behalf of Mr. Crawford?
No, sir.
Ms. Bailey, Ms. Harris.
Nothing, Your Honor.
Mr. Crawford, I'm going to set your bond at $50,000. This is maybe a first degree felony. I think it is a first degree felony, but it's at least a second degree felony. And your bond's going to be $50,000 in addition to whatever bond was already set for you. Mr. Crawford, you're going to have a condition of no contact with the alleged victim in this case. The other individual, I don't even know if that person's still in jail or not, but I'm going to ask the jail to keep you away from each other while you're there. Mr. Crawford, you will also get a notice for your court date. In this case, it should be July 7th, and they'll give you that notice, sir, in just a few minutes. Do you have any questions?
No, I got none.
Have a good day, sir. George Konikoff. Mr. Konikoff, good morning. Mr. Konikoff, you're here because you've been accused of one count of felony littering over 500 pounds Mr. Konikoff, there is probable cause in the complaint. I think you're entitled to a bond as far as I can tell. I'm going to listen to the attorneys before I make a final decision on that. Mr. Blunt, anything on behalf of Mr. Konikoff?
Nothing at this time, Your Honor. We were discussing as far as employment, but he has some extenuating circumstances in regards to that, and some medical issues. So nothing at this time, Your Honor.
Thank you. And Mr. Konikoff, you're not on probation and have no charges pending as far as I can tell. Is that correct?
That's correct.
Great. Ms. Harris?
No, nothing, Your Honor.
Mr. Konikoff, I know that you were homeless, according to the complaint at least, you were homeless when this charge occurred. Is that still the case?
Yes.
Okay. You might, if you arrange suitable housing, then you could be a conditional release candidate due to the nature of the charge. It's a nonviolent charge. I know that you just got out of jail, but I know if you're homeless, you're kind of limited in what you can do. For today's purposes, I'm going to set you a misdemeanor bond. Now, this is a felony charge, but I'm setting a misdemeanor bond for the reasons I've already said. Your bond's $2,500 cash or surety. If you are able to obtain housing, you let Mr. McDaniel know that, or let the jail know that. And then I'll see what the state's position is on a conditional release. But right now, I can't give a conditional release to someone that doesn't have a residence. I'm not going to give a conditional release. In the meantime, you've got the right to post the bond of $2,500 cash or surety. And you've got a condition of no contact with that particular property where you allegedly were living at around Walmart. Can't go back there. Mr. Konikoff, do you have any questions?
Nope.
Wish you the best. The jail will give you a notice for your court date. It should be July 7th at 8:30, sir. We have Mickey Walton. Just a second, Mr. Walton. Mr. Walton, you're here for first appearance accused of one count of aggravated battery, a second-degree felony, and one count of, well, this one's another one that's got to be clarified. So, Ms. Harris, the jail sheet says obstructing justice and tampering with a witness, which are two very different crimes. The reason the jail sheet says that is because that's what the complaint says. The jail sheet, they just match the language of the complaint. The body of the complaint says tampering with a witness, a first-degree felony. The front page of the complaint says it doesn't have a statute number, which is the first issue. The second issue is the front page of the complaint says arrest offense code obstructing justice. Obstructing justice is just like a first or second degree misdemeanor. This particular tampering is a first-degree felony, much, much different. So I'm going to find probable cause for what the body of the complaint says. There is probable cause for tampering, and because the tampering allegedly occurred in a second-degree felony, that makes the tampering a first-degree felony. But I'm going to ask that you notify the officer that the front and back of the complaints need to match, and I need not only statute numbers have to be there, statute subsection numbers need to be there. So I'm going to find probable cause in your case for what's in the body of the complaint, which is tampering with a witness, which is a first-degree felony, carrying a maximum penalty of 30 years in prison. Mr. Walton, there is also probable cause for the aggravated battery, the second-degree felony. And I've looked at your criminal history, which is probably, I would say, 20 pages long here. It's pretty lengthy criminal history. Also, in your criminal history, there is a prior tampering charge, which is very concerning. So that's the information I have, Mr. Blunt. Ms. Harris, I'm glad to listen to anything that you would like to tell me before I make a bond decision. Mr. Blunt.
Nothing at this time, Your Honor.
Ms. Harris.
Nothing, Your Honor.
Mr. Walton, on the aggravated battery, second-degree felony, your bond's going to be $15,000. On the tampering with a witness, first-degree felony, your bond's going to be $25,000. Your bond today is $40,000 cash or surety. There's an allegation that alcohol was involved. So there's a condition of no alcohol, and there's a condition of absolutely no contact with the alleged victim. So, Mr. Walton, starting now, you can have no contact with this alleged victim at all. That means electronic, telephonic, no contact at all, Mr. Walton, with this alleged victim at all, unless I modify that or Judge Garcia modifies that condition, no contact. Mr. Walton, the jail will give you a notice for your court date. Whether you post bond or not, they're going to give you that notice. It'll be for July 7th at 8:30. And Mr. Walton, you will get to use the phone in just a few minutes, sir, to try to post the bond. Mr. Walton, do you have any questions?
No, sir.
Wish you the best, sir. We have Sherry Carroll. Miss Carroll, good morning. Miss Carroll, I first appeared to you yesterday after court. My understanding is that the alleged victim contacted our office and wanted to know about a condition of no contact. And it appears that I failed to impose that condition yesterday. That's what my judicial assistant told me when she watched the video. So I asked the jail to make you aware of that in the event you did post bond yesterday. So Miss Carroll, you're just being brought back to clarify that. You can have no contact with the alleged victim or her property, the alleged victim of the grand theft of the controlled substance. So you can't go back to that property, Miss Carroll, and have no contact with the alleged victim. Miss Carroll, is that alleged victim related to you or were you a caregiver? I don't know the relationship there. I want to make sure I understand that.
I was a caregiver, sir.
Okay. You're no longer employed in that capacity, I'm assuming.
I live there. I live there as well.
Okay. So let me ask you, you live there as the caregiver, not as a relative. You were hired as a caregiver and one of the conditions of the employment is living there, correct?
The daughter said she would pay me. I told her to keep her money because me and her are friends and I was helping her take care of her mother.
Okay. So you've got a condition, no contact with the alleged victim and the property she lives in. So if that woman lives there, you can't live there. You still got the bond that was set, but they're wanting no contact with you. When I say they, I don't even know who called. I just know someone called and said, we're wanting to make sure the judge knows we want no contact. And that is a right they have under Florida laws to have no contact. And it's in your best interest too. Now, having said that, if you have belongings there and you do post bond, then you need to contact law enforcement about getting your belongings. Any questions, ma'am?
No, sir.
All right. Mr. Blunt, anything else in that case?
No, sir, Judge. One more thing. To get me out of jail.
He'll have to make arrangements to go there.
Yeah,
Okay.
that'll be okay.
Yes.
That's all, sir.
All right. Have a good day, ma'am. Thank you, Miss Carroll.
Thank you.
Mr. Blunt, that's everything I had on my first appearance list. Anything else from the public defender's office?
No, sir, Judge. Good seeing you.
Thank you. Good to see you too. Thank you for covering for Mr. McDaniel. Corporal, anything else from the jail?
No, Your Honor.
Thank you. Ms. Harris, thank you for covering for Mr. Mitchell. Anything else from the state?
No, Your Honor.
All right, ladies and gentlemen, that concludes our first appearances for today. June 26th, it's 8:55.
Good morning, everybody. TCF Live in hour number 2 on this Super Friday. Good to have you all here with me. Thanks for joining us. Judging from the stats, there's probably a bunch of new people out there. If you have not yet said good morning to us in the chat, please do so. It is a very welcoming group here. We're good folk, and they're a generous folk, too. So I love this group. Everybody here is great. You've stumbled into one of the best communities on LawTube, so enjoy. Let's do this. Let's go to Texas. We'll say good morning to Judge Stevens.
It doesn't give me font Novak. I didn't know if I'd lost it. Oh, and now we recall 25 CR 1049 in the state of Texas versus Christopher Barajas. See, yes, am I pronouncing that correct?
Quick pause before he really gets going. Lindsay, thank you for gifting 10 memberships, and it looks like you landed right on one of our new friends. So congratulations, and again, thank you, Lindsay. Appreciate that.
Okay. And Mr. Marino is here representing you, and as you know, you are charged with this third-degree felony of online solicitation of a minor. I don't see any other added charges, huh? So there's no enhancement here on this.
No, sir, that's it.
You're looking at a third-degree felony, which carries with it up to 10 years in prison. And nobody, of course, wants something like this on their record. That looks bad. Try to get a job or get into the priesthood and you're gonna have problems.
I guess.
What are you gonna do today? It's an announcement and, yeah, it's
getting
9 months old.
Well, I'm announcing stalemate. Ms. Moore and I, we've tried, but we're not getting anywhere. We're just going to get a trial. All
right, we've just finished our 615th felony jury trial, which according to the internet is a world record, and that's what we do here. We try cases.
Can I put it out as far as possible? Because I got an intox man, I got a child possession of child pornography and a sexual assault of a child all this summer.
I'm setting in the ball, Judge. Full through.
Okay, that takes care of that, Judge. Okay. I didn't have to bring it up.
All right, so here's the deal. After this, ain't no deal. So, I mean, okay, that's what we're gonna put on. This is our, y'all had an opportunity and we're gonna set it, and that's what we do. I enjoy, I like trying cases. Something different happens in every trial. And you seem smarter because you learn something new in every trial. So it's a remarkable thing. It's not like, oh, that was just like the other one. But that's what we do here. This is a trial. And that means, and he's eligible for probation.
Yes, sir.
Stand by. Let me just look at it.
Don't give any record of it. No.
Just for him too.
Hey, you've got a copy of this, proper cause?
Oh, yes.
Yeah, okay. Okay. It's settled the trial document. That's what should be done. Hey, Bruce.
He's in the back.
John, you're up. You just get a resetting from her.
All right.
Hearing online, I'm ready. Okay.
No, let me get Bruce out of the way.
Yeah. So, wait, come here. She was ahead of us.
Is Reginald Allison here? Reginald Allison, have you talked to your attorney?
Well, I haven't seen him today.
Me neither. And I'm kind of disappointed because we're late on this one.
Pick up on the phone.
What's this from probation? What's the status on that?
So are we excusing?
What's the probation?
Well, Your Honor, this was just.
Is Mr. Allison doing well or not? That's all I want to know.
He's been on my case for a month and is doing well.
Isn't that's what that's all we're looking for?
It's just to see how he's been doing.
Okay, what do we want to do next?
I mean, at this point, Your Honor, I say he just stay on my caseload and proceed the way he is, so.
Great, come
I
on.
think that TRP.
Do I need another review?
I don't know. If anything happens, I can file documentation.
Hold on, everybody's talking at once. What did you say?
There's a pending TRP.
What about the motion to revoke probation? Stay.
Dismiss it.
What do y'all want to do?
We'll dismiss it, Judge, if you're doing well.
Is that what we're gonna do?
Yeah. Something happens, I can refile.
All right. Mario Jobo. Thanks for being here on time. I appreciate it. Show the respect that is always good for you. Always nice. Okay, so Ted, we don't know where Theo is, but Mario Jobert is here, right? Mario Jobert?
Marlo
Jobert. In two cases, 26 CR 392 18-298333. There is no answer in the courtroom. Oh,
Well, it's
do we know? They never,
Thank you.
Marlo Jubert. Cases.
No response, Your Honor.
All right.
Hold on, it's just maybe it's on his back.
He's back there. State, who's got that one? Marlo Gilbert. Are you ready on this? John's isn't here, but I'm gonna wait for him to get here and we're gonna have a hearing if we need to. It's a motion to revoke, right?
Yes, sir. I spoke with him yesterday and from my understanding, I believe we're gonna work it out.
Yeah,
he
but
reached out to me yesterday.
it's always handy to have their presence. They're not around. He's already late. Not the first one today, which is, you know, what happens in when I was in federal court for 20 years and you rolled in late? You didn't hear the end of it. It's, and your taxes got audited. And not really about that, but generally the lawyers were on time, which was what should be happening.
So personally, I think the judge just slipped with the truth there. He talked about your taxes getting audited. Somehow that wouldn't surprise me. So he's struggling to find the next contestant. We will keep an eye on his courtroom. Good news, Dungeon Court is active this morning. For those of you who are new to the channel, stick around for the last 30 or so minutes of the show for the best worst courtroom you've ever seen. It's our Friday guilty pleasure here at TCF. Let's do this. Let's go to Michigan. We will check in on Judge Aquilina.
Okay. This is docket 25-1992 FH, People of the State of Michigan versus Michael Antron Johnson. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan here at probation.
Agent Fleming, Elmore County Probation, Michigan Department of Corrections.
Assistant Public Defender Jacob Riley appearing on behalf of Mr. Johnson, who is present to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. Sir, you were placed on probation after pleading to stalking, the misdemeanor stalking, punishable by 1 year, and domestic violence, third offense, punishable by 5 years. I have a request for a bench warrant that the court signed on June 18th, 2026. Counsel, you and your client have reviewed that?
I have, yes, Your Honor. We have reviewed. Yes,
and sir, have you taken any medication yesterday or today?
No, Your Honor.
Are you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
And you had enough time to speak with your attorney?
Yes, Your Honor.
And sir, this probation violation asserts as follows. Count 1, on or about June 14th, 2026, defendant engaged in assaultive behavior toward Alyssa Mix. Count 2, on or about June 14th, 2026, defendant had contact with Alyssa Mix. Count 3, on or about 6/14/26, defendant engaged in assaultive, abusive, threatening, or intimidating behavior by physically assaulting Alyssa Mix. Before we proceed, were there 2 instances?
Your Honor, there was the new charges, and then the added count 4 is in regards to alleged jail calls that Mr. Johnson has made.
So first let's get to count 4. What is that?
The added count 4 is the new issues, Your Honor.
Okay.
So counts 1 and 3 all resulted in the domestic violence third case that he currently has in district court.
Okay, what about count 4? There's an amendment. So what is that?
So count 4 is the alleged jail calls that Mr. Johnson.
I need do you have it written? So on or about when did he make these calls?
On or about June 15th and June 16th, the defendant had contact with Alyssa Mix.
Gotta slow down, ma'am. I don't have speed writing here.
Sorry.
On or about what, June?
June 15th?
Or June 16th?
Yes, Your Honor.
2026.
Correct, Your Honor.
Defendant contacted
Alyssa Mix.
from the Ingham County Jail
Correct, Your Honor.
using his account.
Correct, Your Honor.
All right, do you understand all 4 counts?
Yes, Your Honor.
Now, my question is, before we get to new charges or anything else, count 1 says on or about 6/14, he engaged in assaultive behavior. Count 3 also says he engaged in assaultive behavior. So are these 2 different instances on the same day? Is one verbal, one physical? Otherwise, they look duplicative, so I need some more information.
So
do we know?
For count 1, it was for the behavior. And the count 3 was for engaging in assaultive, abusing, threatening, or intimidating behavior by physically assaulting her.
So what's the behavior in count 1? Was it physical assault as well? Were there 2 instances of physical assault? Otherwise, it looks like we're piling on.
Okay, they're the same, so we can dismiss count 1.
Thank you. When in the future, make sure we're clear as to what you did, because otherwise what happens is, for your information, is it looks like we're piling on, and then in the Court of Appeals is gonna say you didn't provide adequate notice. So if he hit her in the jaw in count 1 and then kicked her in the rear end in count 3, that's 2 different assaults. Okay, it could be deemed 2 different assaults. But otherwise, it looks not good for us, and it looks like we don't know, and we're just piling on, and we're in notice state. So I need you to be specific in the date, place, occurrence, okay?
Yes, Your Honor.
Okay. Are you waiting further arraignment counsel?
Yes, Your Honor.
And on behalf of the people, there are new charges in regard to all of these things?
Correct, Your Honor. There has been a new charge of domestic violence, 3rd offense, habitual 2nd. There was a PCC in district court here in this county yesterday, and there is a preliminary examination set on July 2nd at 9 a.m.
And what about the contact? Was that charged, or is that something?
It has not been charged as of yet, Your Honor. Our office has not had a chance to review those calls in their entirety.
So we'll hold this all in abeyance?
So yes, we would need to hold this all in abeyance at this time, Your Honor.
All right. Can we set this for then August? When do you think it'll be over? August or the end of June, or what?
With the exam being on July 2nd, if there was an exam or a waiver at that time, the case should be up here, Your Honor, at the beginning of August.
Okay. So let's set this for August 5th at 11. I don't know if we need to move that or not, so council will have to keep in contact and then know that you don't need my permission to move it, because we will need to see if it gets bound over, when it gets bound over, and if you need a transcript. So it may very well be later than that. All right?
Yes, Your Honor.
And so that would be for the PV, and I'm just gonna make a note, he was arraigned. Sir, your attorney can ask for bond, denied. We have a long history here. There were two victims, Dexter Jones and Alyssa Mix, that you were not to contact pursuant to probation. You ended up pleading to domestic violence, third offense, and aggravated stalking was dismissed, attempted interfering with electronic communications was dismissed, assault or assault and battery was dismissed, the habitual offender offense notice was dismissed, and assault with intent to do great bodily harm less than murder or by strangulation was dismissed. You got an absolutely unheard of plea agreement. So your attorney did a good job for you. Prosecutor gave you the benefit of the doubt. This court gave you the benefit of the doubt. Probation's been working with you. Now I have more allegations. No contact means no contact. Mr. Jones, Ms. Mix does not exist in your world. I've already gone through this with you. And here's how this works. I revoke probation, and send you to jail or prison. But meanwhile, if this continues between now and our upcoming hearing, it's contempt. And I want to explain to you what contempt means, because you kind of be on the same page, and I need to inform you of this because this is a notice date and you have an absolute right to be noticed of the consequences. So contempt carries with it 93 days and or $7,500. That's criminal contempt. You violate this court's order, this no contact order, and it's 93 days. I'm going to tell you here and now, I can and may give you 93 days for every phone call, because every phone call or contact with a third party or otherwise is a separate incident. That jail time does not count against the primary offense because it's a separate offense. So if you like to wear that jumpsuit and put a hold on your life, go ahead and violate. You want to enter prison, go ahead and violate. I'm about public safety. I put you on probation instead of jail for rehabilitation, for reformation. So you learn a different way of life rather than stalking and being in contact with someone who does not want your contact, who is not safe with your contact. And so we have public safety. Now, if you can't be safe, then the prison awaits. All of this is within your control. Not my control, not probation's control, not the prosecutor's control, not your attorney's control, your control. So you decide if you want to be a free man who's worthy of being rehabilitated or an imprisoned man who has law enforcement watching every single thing you do, and the most fashion-oriented statement you're going to have is some Crocs in a jail jumpsuit. Maybe you'll be lucky to not always wear blue. Maybe you'll wear orange or yellow or red or some other Crayola color. If that's what you want, that's what you're going to get. Have I been clear? Yes, ma'am. Do you understand what no contact means? Yes. Tell me.
Yeah. Can't have no contact with the victim, can't be within 1,000 feet of where they work, live, go to school. If I'm at the store or she's at the store, I gotta automatically leave. No ifs, ands, or buts about it. If she's my neighbor, if I get a house and if she end up moving right next door, I gotta find a new place to go.
Sure. She shows naked, you call 911. No messages through Hallmark cards, flowers, carrier pigeons, third parties, smoke signals. Don't get creative, because see what happens is you're in that jumpsuit. I don't play on this, sir. It is public safety. It is her safety. And she should not live in fear of you being around. Now, I don't know what you're talking to her about. I don't know what the great need is, and I don't care. No contact means she doesn't exist on this planet. She's been erased from your life in every way, shape, and form. Do you understand?
Yes, Your Honor.
You will be in front of me immediately if there is another call from the jail. And if you think that you can use somebody else's name, use their phone privileges in the jail. These prosecutors know exactly who you are. And they will figure it out. Yesterday, I had someone who did that 1,141 times. He is now on his way to prison for 7.5 years. Do you want that to be you?
No, Your Honor.
Then quit it. Now, I say this, although we have a presumption of innocence on this, and it's by preponderance of the evidence, so we go to hearing on this probation violation, unless it's contempt, and then it could be beyond a reasonable doubt. We'll see which way we go. Bond conditions for the safety of the public and the safety of the victim. And that's why I've given you this. And I'm presuming that that happened because I am about public safety, and that's what bond considerations are. So at this time, bond is revoked, and I don't care what you got going on in your life. You can't keep Ms. Mix safe and stay away from her. That's the end of it. Anything else for the record on behalf of your client?
I have nothing further at this point, Your Honor.
On behalf of probation?
No, Your Honor.
On behalf of the people?
The only other thing, Your Honor, and it's just so the court is made aware of it, this is not a new count that probation has added this time, but it is also my understanding that when the defendant was released previously after sentencing, he did not report to probation. So I don't think.
Did he ever report?
I don't
know, Your Honor.
Well, that ought to be a violation. And I'm adding it right now. Sir, I sentenced you, let me see,
June 3rd.
June 3rd. Did you make an appointment? You had 24 hours to make an appointment with probation.
So I went to probation the next day, and I went there the next day, filled out the paperwork, and I gave them my sister's phone number.
Just a minute, did you fill out the paperwork to your knowledge?
No, Your Honor. I attempted to get a hold of Mr. Johnson several times via his sister as well. She told me she had no contact with him and had no idea where he was at.
She knew exactly where I was. She knew I was at the mission. She could have came up there.
The mission down here?
Yes.
You walk over here, it's not that long of a walk, and you make the appointment.
Your Honor.
Yes.
I did go across the street to the mission and I handed them a card and I advised him to report to me immediately or come in that following Monday because it was a Friday and he was arrested on that Sunday.
So I'm adding account 5, failed to make and keep an appointment with probation within 24 hours. These are all violations that should be told to the court before I proceed, or as I'm reading this. That is definitely an allegation that I want to talk about. Even if I don't do anything about it, I certainly can have a chat with them. Sir, she did everything but call law enforcement to do a ride-out to find you. Your obligation. So let me just tell you, you have a 5-year felony, and if I find that you are not good for probation, let me just look at your guidelines for a moment. But given all of this and the continued contact, I don't even have to follow that. I can make a record that you simply can't be safe. Your guidelines are 14 to 29, and you have a 5-year felony, which is 60 months. So I can do 40 to 60. How's that feel?
Not good.
Well, then I need to see some improvement because otherwise that's very well what I may do to keep everybody safe and to teach you a lesson, get you rehabilitated once and for all. behind bars in prison. Anything else?
No, Your Honor.
No, Your Honor. Thank you. This should be set along with his new, charge if it comes up. And I guess, what I'm gonna do on the, let's do a PV pre-trial, because we may not be able to deal with the PV until there is a resolution, if there will be a plea, and then we can globally resolve it. So if there's a pre-trial and we still can't deal with the PV, then it doesn't need to be on my docket for a hearing. You can just deal with it as a pre-trial. We could do that. We could take a break at 11, or you can move it to 1 o'clock if you prefer. Would you like me to do 1 o'clock? Because I know you do pre-trials then. It's up to you.
Either way is fine, Your Honor. If we do 1 o'clock, I have no issue with that.
All right, let's do 1 o'clock instead of 11, and that's really, because it was a pretrial, then we'll just move it along to the final pretrial stages and all of that. Is that all right with you, counsel?
Yes, Your Honor.
Perfect. Any questions about what I mean, sir?
No, Your Honor. I got one.
What?
So, when I got out on the 3rd, I get out, I go straight to the mission. The minute I get there, I settle in and I leave out. Her friend, I guess.
Sir, if her friend, you can talk to her friend, but not about her.
No, it's not the point I'm trying to get with.
You don't want to talk about the underlying issues because your rights are going to be impacted. So if this has anything to do with these alleged 4 counts, 2, 3, 4, or 5, you are squashing your rights, literally. This record.
Thank you, Your Honor.
Your Honor, may I approach real quick?
Alrighty, friends, hour 2 of TCF Live on the Super Friday. Let's go back to Judge Stevens, new contestant down in Texas.
2022, he pleaded truthful, failing to enter and complete the moral recognition therapy program. So we're back on that one.
Yes.
All right, are you Jovan Ray Lede Hopkins?
Yes.
Here with your attorney, Mr. Weston. State's attorney. In 17-27711, there's a motion to revoke unadjudicated probation filed October 23rd, 2024. I don't know why this one's rolled on for so long on administrative, but here we are. That's headed toward 2 years. What are we doing today?
I believe it's just a hearing. I think all the allegations are all administrative, and
we're going to deal mostly on number 2, the moral recognition therapy that he was ordered to at the beginning of probation, for which he earlier in 2022 pleaded true to failing to complete that properly. So we know we've had a deal that we brought up that was made a big deal, and he knew that was important. And so we're back today, 3.5 years later, and it's the same old thing. Correct. Okay. Does the defendant here, who's here with John West, his attorney, waive a formal reading of this motion to revoke unadjudicated probation? Can we proceed in summary?
we can, Your Honor.
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. In summary, this motion states, November 6, 2017, in this court, you were sentenced to 5 years in prison.
No, Your Honor, he was sentenced to 2
So
years.
hold on. What was it? You were you were placed on deferred or unadjudicated probation for 5 years. You weren't found guilty. And that was in 2017. That deferred or unadjudicated probation has been continued through the years. And here we are today, and he's still on deferred or unadjudicated probation, correct, everybody?
This was the order.
Is that true, sir? All right. Allegation 2 states you failed to provide verification of entering and successfully completing the moral recognition therapy program as directed by the probation office. That's a violation of condition 29 of your deferred or unadjudicated probation order. And that states enter and successfully complete moral recognition therapy, comply with all rules and regulations of the program, and pay all associated costs. That was an order that you signed and I signed back on November 2017, when I was just almost a teenager. Is all of this true and correct?
Yes, sir.
Are you pleading true to allegation number 2 voluntarily and because it is true as it is alleged?
Yes, sir.
Do you understand that a voluntarily and knowingly made plea of proof to one or more violations of probation, that is enough to grant motion to revoke probation? Your probation could now be revoked. You can now be found guilty and sentenced up to the full range for this state jail felony, which is no less than 180 days up to 2 years in the state jail. You have 162 days credit already. Understanding all of that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. What does anybody want to say?
I think, can I ask my client some questions, John?
He's under oath.
Yes. Mr. Hopkins, you never finished this moral recognition therapy. Is that true?
Yeah, I remember, but I never finished.
Okay. Tell the court about that. What happened? What went on?
When I went, they gave me the book. Then he said he was going out of one.
Did you hear him okay? You need to speak
a little louder and clearer.
I got the book the first time, and he said he was going on vacation.
So who's he? You say he.
Oh, I don't know. I don't get his name.
The person that was conducting the class?
Yeah.
Okay, that's fine. And he gave you the booklet and then told you he was going out of town?
Yeah, he went on he said he was going on vacation.
Okay. And did he come back from vacation?
I never talked to him again.
And did you talk with your probation officer about getting the class again? Because you've been on probation you ordered to do this a long time ago, is that correct? You ever followed back through with this to take care of it?
Yeah, I asked him. She gave me a note to call. They never answered.
So it's his fault? It's his fault. It's the probation officer's fault that it's taken you 8 years to not do anything on this requirement.
The class they never had another class.
So it's somebody else's fault. They never had a class, so it's somebody else's fault.
Yes, sir.
That's your, okay.
Class.
Wait, hold on. What's the probation say about that? Is it your fault?
No, Your Honor.
Oh.
We actually referred him online as well to do the class. And the providers usually reach out to them, and I'm assuming he never answered or got in contact with them because he never.
Who's the probation? Who's his direct probation officer?
Me.
Okay. Oh, you've interacted with this man about all of this?
Yeah.
Well, the lady is here who's your supervisor.
Yeah,
she's saying it's your fault.
Yeah, the paper, I reached out to them, but they never reached back out to me. The paper she gave me.
What do you mean you reached out to them? This is your responsibility to complete.
The class that I'm supposed to take, I reached out to them. She gave me a number to call them, but they never called back.
How does this work?
So we refer them to PDS. It's online.
Okay, hold on. Play like I don't know the initials stand for something.
It's personal development seminars. We refer him there.
Yeah.
Write down all his information, the name, his address, phone number. I email it to them and they get in contact with him. Now it's up to him to answer the phone. If he doesn't answer the phone or doesn't reach back, then they can't ever schedule the class.
And this has been your experience as, you've been a probation officer for how long now?
4 years now?
And this is your experience in all cases, where moral recognition therapy is required, which is in many cases.
Yes, sir.
This is the way it works all the time.
Yes.
How many problems in the thousands of cases that we've handled over 4 years, how many problems have we had where the defendant says, oh, well, I did all I can. They never reached out to me.
Not many.
Well, I mean, does it happen?
No.
Okay. It doesn't happen. Congratulations. We have 5,000 probationers. You're the only one who can't seem to communicate, but it's your requirement. You signed a plan, you signed a contract when you were placed on probation. And what happens is you got to put out the effort. So, and here's the problem is that we made a mistake. I gave you a chance a while back. We had a hearing on this, and back in October of 2022, where you failed to report, failed to provide verification of performing community service, and failed to complete the theft prevention class, and failed to provide verification of entering and successfully completing moral recognition therapy. That's going on 4 years ago. And he hadn't done a thing since this last hearing of 4 years ago?
For that moral
For that moral correct?
No,
No. That's 45 months have gone by. Times 30 days. 1,300 days. And you couldn't squeeze it into your busy schedule? You see anything wrong with that? You're nodding. She has to take something down. Yes?
Yes, I do.
Okay. On balance, Ms. Vega, on balance for the defendant, how's he doing on all the other stuff? The other requirements, he's just probation. Is this just the only thing he's not doing right, or are there other problems? I know there's money problems. And I'm a little, unless somebody's going to convince me that he's got money that he's not paying.
We're not concerned about the money, Judge.
But I am, because it's an order of this court. But if they're unable to pay, that is a defense, and I honor that. Is he able to pay as far as you know money, or are you working somewhere?
At the moment.
Yeah. Well, it's hard to get hired when you got some problems here, criminal
I'm
problems.
gonna get my trick card.
See them. You've been on probation now going on 9 years, almost a decade, and we're still having problems. See? And this moral recognition therapy is very important because it's a class that helps you make the right decisions. You seems like you're not making the right decision. We're in the same situation we're in. Let me ask you, are you employed now?
No, sir. I was
Sir?
No, sir. I was taking the class for.
Okay. What's your education status?
I graduated
From
Memorial High School.
From high school. After high school graduation, what have you done for education? Anything?
No, I was taking
Okay.
an IT class.
Okay. So what do you do during the day? When you're not in jail? What do you do during the day?
With my uncle cutting grass.
Cut grass? Okay. How's that going?
It was going good.
Well, how much do you make in a year?
He just paid me $20 like a yard.
Okay, 20. Okay, how many yards do you cut in a month?
Like
20 yards? 20?
Yeah.
Is that right? Okay, and it's $20 each? That's 400 times 12. That's
4,800.
4,800.
I'm not good at math.
Are you filing income tax returns on that money?
Yeah, I was filing it.
You file?
Yeah.
Oh, well, we want copies of your tax returns. Can you get them to her tomorrow?
Yeah, I can.
Where are they?
In my phone.
You keep your tax returns in your phone?
Yes, on my email.
Oh, electronically filed. Okay.
Yeah, well, good luck when your phone gets
Well,
taken or something, huh? How do you, the IRS doesn't find that amusing.
well,
Anyway, that's your problem.
yeah.
What do we want? Okay, what else on this case? We're gonna move forward here. He's, from the very get-go, he was charged with burglary of a building.
Oh.
And where are we on, was there any restitution owed in this?
There was, Your Honor.
Is there still owed?
Yes, sir.
Yes.
How much?
4,448.
What was the amount at the
That was the
beginning?
amount.
Wait, he's making $4,800 and he can't get one dime to the victim? Are you kidding me?
I was gonna chop your pay when I got my ankle tagged.
Oh, you think it's been, how long you been on probation? 8 years. We're gonna wait on you? You were supposed to do it immediately, start paying something back. No, this is, it's all about, this one is, the victims don't matter, it's all about you. That's why you got in trouble in the first place. No, I don't like this.
Your Honor, another option we have, besides sending him to prison right now, is he's on deferred. You could revoke his probation or deferred and place him on regular probation to pay the restitution back, see if it happens, and there's more recognition therapy. And if it doesn't, then prison's the only option. But right now we have another option between that.
You mean like we hadn't done anything in 9 years?
I know.
He's waking up from a coma now?
I'm just giving options that if the court was trying to get the restitution, that's another option we could do.
Okay, what state asking for? I can sense Mr. Ham's frustrated.
Oh,
yeah.
We all are.
I understand.
Then the victim is, I'm sure.
Judge, I would like to ask you to revoke him based upon his plea of true count 2. I would ask that whatever punishment that you give him, that we add the restitution to the judgment there. I think that's the best way to resolve this because of the
terrible. Well,
it's horrible that he's done that, Judge. But the bottom line is
it's terrible that the people hadn't been paid back, but he's bragging about how much money he's making.
My frustration with him is with the state jail felony. I'm not sure that we can. I think we've done all we can do underneath the legal requirements of the time frame we can work with him on this probation.
What's his restitution? How much?
$4,448.
That's correct.
Anything else?
From the state judge.
Okay, so we're going on this motion to revoke unadjudicated probation here. I guess the one that was trying to get the most recent one.
That's it.
The one in 24?
Yes, sir.
Yeah. All right. In summary, this motion to revoke probation states that on November 6, 2017, in this criminal district court of Jefferson County, Texas, you were placed on 5 years deferred or unadjudicated probation for burglary of a building, a state jail felony. Is all of that true and correct, sir?
Yes, sir.
And allegation 2 states you failed to provide verification of entering and successfully completing the moral recognition therapy program as directed by the court in the probation office. Have you failed to do that, sir?
Yes, sir.
Are you pleading true to that voluntarily and because it is true?
Yes, sir.
Yeah.
Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation? Your probation can be revoked. You can now be found guilty and sentenced up to the full range of punishment for a state jail felony. And that's no less than 180 days up to 2 years in a state jail. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. 3 states you failed to pay court-assessed fees as directed. As of September 23rd, 2024, you were in arrears $9,234. My primary concern is you were ordered to pay restitution in the amount of $4,448. What is the total amount of amounts the defendant has paid over the course of his probation?
$1,421.
Okay. And that's over since 2017.
Yes, sir.
And I think we talked about that. We're going, that's going on 10 years and 120 months. And over that period of time, each month, well, you're making what, $4,800, what, per month? Is that what we said?
That's what I heard you say, Jim.
That's what you said, which is times 12.
It's less than 60.
I think he said 4,000, so I think it's 4,800. I'm gonna give him that credit. So it's 4,000, which ends up being 48. 4,008, 48,000 a year, almost 10 years. So my God, he's made almost $500,000 in a decade this way. And not one dime went to restitution for the poor people. Is my math right here, everybody?
I think it's a little off, Judge, which is odd for you.
It says he makes 200.
Right, so 4,800 a year.
No, it's 4,800 a year.
Right, times 10, so
which is
40,000.
$4,800 a year, not 48,000. 4,800 a year, right?
Right.
Okay, and this has been 10 years, so that's 48,000 over a decade.
Right,
but not one dime has gone back, and he's paid a total of 1,000.
$421.
1,420. Where'd all the other monies go?
Years.
How old are the children?
I don't know, 1 year old, 4 year old.
Okay. How about them? What happens to them when you go to prison? Do you care?
Yeah. Yes, sir. All right.
You know, that's where we're headed.
My daughter had dialysis.
Sir?
My daughter had dialysis.
Yeah, so you don't follow your rules of probation, so you end up going to prison. Whose fault is that? It is. Meanwhile, you've got responsibilities at home and children who need care. Where's the mother of the child?
She's there.
She what?
I said she's there.
Is she employed? Well, she works in the house. Homemakers have a responsibility, and it's generally hard work. All right. What's state asking for?
Judge, reading through the original PSI, the fact that this burglary building was a break into a pharmacy, and it was out of the kindness of the individual that owes the restitution. He made a recommendation that this young man not get any jail time then. I would have actually harped on it at the time because of the circumstances, but he didn't meet those needs. He's young. Hopefully he'll turn himself around, but I think what's appropriate here, because this is a state jail and the facts of the original charges, that we give him a sentence of a year's state jail time.
All right, anything you want to say? How much do you have? How much money do you have to pay the victim today? And do you have some money squirreled away somewhere?
Yeah, I don't know how much on there on my phone. I got money on my phone.
I'm sorry.
I got money on my phone. I don't know.
What does that mean?
Like on the app. Apple Pay.
How much is that?
I don't know how much on it.
Well, about how much?
Like $200 or $300 on there.
Okay, here's what I'm going to do. I'm going to find, if there's nothing further, I'm going to find that there is sufficient evidence supporting this motion to revoke unadjudicated probation, to grant it by a preponderance of the evidence or greater, as allegation 2 has been proven true, that the defendant has failed to provide verification of entering and successfully completing moral recognition therapy again. And this is after we had taken this up a few years ago and found it true. The defendant has nonetheless had an opportunity to do it and has not essentially put in any effort in moral recognition therapy over the course of his term of probation, which is now 9.5 years, over 9.5 years. All right, so this motion to revoke unadjudicated probation is hereby granted. Earlier in this case, the defendant pleaded guilty voluntarily. He was mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at that hearing to find you guilty beyond a reasonable doubt. We instead placed you on deferred or unadjudicated probation. That deferred or unadjudicated probation is hereby revoked. I now find you guilty beyond a reasonable doubt of this underlying state jail felony of burglary of a building. You were hereby sentenced to confinement in the state jail for a term of 2 years. And you have 162 days credit, which means you have a lot of time in jail, in state jail. But what I'm going to do is place you on regular probation. And that will be okay. What am I able to do here? How much can I place him on time on regular probation for?
Should be 5 years.
Can I?
Leave.
I thought you could only do no more than 10 years, right?
You can't do more than 10 years.
Sir?
You can't do more than 10 years.
Even when it's revoked and.
It's total of 10 years. I don't know.
And he's been on probation
Since November 2017. Let me check that date, Judge. Correct, November 6th, 2017. So whatever the math turns out there.
Anytime, I guess.
Here's what we're going to do is we're going to place him on this probation for the balance of the time. That would make the anniversary of 10 years from the time he was placed on probation.
It's approximately 16 months, Judge. We've got 4 months before he hits his anniversary and then an additional year. Don't forget. What's your
So what we'll do is place him on that for that period of time from today to November 6th, 2027. And we're going to review this in 3 months. And if you hadn't come up with substantial amount of restitution here, we'll be back on a revocation, and then it could result in 2 years confinement. So it's up to you to try to get these people paid back that you're responsible for. Do you understand?
So,
Everybody understands where we are on this. You got responsibilities to yourself and at home.
listen,
Live up to them, sir.
yes, sir.
That's, here's this one.
Now in hour 3 of this wonderful Super Friday here on TCF Live. I hope you're all enjoying the show thus far. Let's go back up to Michigan. We'll check back in with Judge Elmore, new contestant there.
Miss Odell, your PSI, ma'am. Yeah. Yep. Thank you. I do, just make sure I got it. All right, our next file here today is People in the State of Michigan versus Robert Cole. There are actually 2 files here this morning. The file numbers are 26-3663 and 3675 FH. Appearances from counsel, please.
Thank you very much, Your Honor. Attorney Robert Ringstrom, Assistant Prosecutor for Sauk County.
Thank you.
Robert Hartzell from Mr. Cole.
All right, thank you. Also here this morning is Miss Laura Odell. She's the agent from the Department of Corrections, serving as the probation officer on these 2 files. One second. When I said probation officer on these 2 files, one, she is a probation officer. The other one, she's making a recommendation because we have a new sentence. 1 second. There it is. All right. In file 3663, we are here for the probation violation sentencing. The defendant was found guilty of based upon no contest pleas to 2 counts, specifically counts 7 and 8 out of, I think, 13. And then the other file, the defendant pled no contest to 2 counts that are related to those, which of course are the new R&Os. The court has gone over the probation violation recommendation report, which is a CFJ 491. As to that, Mr. Ringstrom, any amendments, corrections, or objections to the contents?
No, Your Honor.
Mr. Hartel?
No, Your Honor.
All right, one moment. Right. As to the PSI in file 3675, any amendments, corrections, or objections to make there, Mr. Ringstrom?
No, Your Honor.
And Mr. Hartel, same question.
No, Your Honor.
Right. This court did not see any other corrections. I'm also going to state that on the 3663 file, the court also has reviewed the original pre-sentence investigation report. All right. Allocution, Mr. Ringstrom.
Your Honor, I've known Robert Cole for a long time. I actually was his juvenile attorney there for a while and all that stuff. I've always believed in him. Unfortunately, he's not believing in himself at this point in time. He's pretty much given up. I don't know what else there is to do for him. I agree with the recommendation and it's the court to follow it.
All right. Thank you. Mr. Hartel.
Thank you, Your Honor. With this being a no contest, I'll not openly allocute, but what I will say is I would ask the court to go on the low end of the guidelines. With that type of a straddle cell, the court could give him county time. I'd like to believe that whatever needs he has, emotional and mental health, I'm not a medical professional. I know he does have needs, but I believe that it's at least possible to get that here at the county level. I know his mother's been in contact with our office, being supportive, wishing him the best. I know there was a loss in his family not long ago. I won't go into too much detail because that's probably not my place, but there is a lot going on they are dealing with. I know we didn't submit a mitigation report this time. he is going through a lot and it's been a little difficult to communicate with him. He's been friendly with me, but I know he's going through a lot. And I'd ask the court to consider allowing him to get what he needs locally versus sending him to prison. Thank you.
Oh, thank you, Mr. Hartel. Mr. Cole, you have the right to make a statement today. Is there anything you wish to say before I issue a sentence?
No, sir.
All right. Well, I have to make a few statements. I have to explain the justification to establish the reasonableness and proportionality for the sentence. Now, looking at the defendant's prior criminal history, he has, I think, 10 entries. 3 were dismissed, looked like in relationship to other cases, or in other words, resolutions for other files. What we have here is a pattern of violence. When I say criminal history, initially I was only referring to juvenile history, because there's also another 7 entries for his adult history. As a juvenile back in 2018, it began with domestic violence here in at least in the family division of this court. He failed to comply with his terms of probation with multiple violations, including use of controlled substances, specifically marijuana back then. While he was on that juvenile supervision, he picked up more charges. One was an act of domestic violence alleged, but it was dismissed. However, at about that same time, he had a second file of domestic violence. And he failed to comply with the terms of his juvenile probation again. In fact, he picked up another file in about 4 months that sure enough involved violence and destruction of property. And continuing his pattern, he violated probation in that file. 2022, having not learned his lessons from detention, probation, fines and costs, he was right back to domestic violence and destruction of property yet again. And of course, while that case was on bond, he violated terms or conditions, it looks like, of that bond, also of his probation, right back to marijuana and methamphetamine, and violating programs, looks like at the detention center over in Roscommon. He absconded from supervision at another place. So that didn't work. Also in 2022, he picked up a case downstate. Sure enough, it involved here an assault, resist, or obstruct a police officer, which of course is what we're here for today. And it took him almost 2 months before he got in trouble while on that probation, because he picked up the charges here in Missaukee County. Again, given treatment, yet again, had some violations. His adult criminal history began in 2024, just 2 years ago, and there was a domestic violence that was dismissed. While he was on bond for that, however, he was picked up for destruction of property, domestic violence, and interfering with a communication device, which means not taking a phone out or stopping somebody from using a phone to call for help generally. Sure enough, he violated probation within about a month of that plea and sentence. Well, with that violation of probation, he picked up a meth charge, and this was last year. Gave him 120 days in jail, and almost immediately after getting out, he picks up another domestic violence case, 2025, and that's one of the cases. Wait, is that one of the ones we're here for today? Hold on. Nope, that's the 84th District Court. I'm sorry, but yeah, given probation, and looks like he had violations there because he was terminated unsuccessfully. Well, it only took him about 2 months before he violated that probation by committing further criminal activity. That was disorderly conduct. Then we get to 2026, and here we go. We have domestic violence offense as a felony, making it up to a 5-year now. And sure enough, he's been violating his terms and conditions of probation. And he violated that with the new criminal charges of assaulting, resisting, obstructing police officer. So the defendant clearly is not learning his lessons. Everyone's attempt, whether it's, and I'm not criticizing anybody, that's actually their benevolence. Everyone's niceness has not worked. And for the record, the defendant can't even lift his head to look up today. So here's the sentence of the court. In file 3663, that is the file for which he's on probation. And in that file, he was originally convicted of domestic violence as a third offense. And he was given a chance with probation. The scoring guidelines is 0 to 9 months. I find that those scorings are not helping. And I find that there are reasonable grounds to go and give a confinement sentence. I also find that you really can't score very well the repetitiveness of drugs, destruction of property, doing what he wants, and beating up on people. So I'm going to exceed those guidelines. And I don't need to, but there are definitely substantial and compelling reasons, because everything being done locally isn't helping Mr. Cole. I wish we had more programming, but we do not. And because the Lansing doesn't give me enough tools, I only have so many options. In that file, the court revokes probation and sentences the defendant to a prison term of 13 to 60 months. And the defendant receives credit that's contained in the probation violation recommendation report. And how many days is that, Miss? I think it's on page 4. 151 days of credit. In the other file, 3675, I don't need to repeat myself other than to say nothing else has worked. He violates bond, he violates probation, he commits the same offenses over and over. He gets picked up for new charges while on probation. So it's not merely a simple probation violation, he's committing new crime. And in this particular file, the court sentences the defendant to a prison term of 13 to 24 months. Yes?
Your Honor, you are aware that we believe it has to be consecutive sentencing.
Yeah, I'll get to that in a second. Well, wait a minute. Does it have to be? Because it's a felony committed
while incarcerated.
While incarcerated. Yes, thank you. Well, that's okay. I'm fine with that. Thank you for reminding me about that. But I'm going to tell you, everything locally just doesn't work for Mr. Cole. And I can't even get Mr. Cole to look up and participate today. And I understand he's sad, and I appreciate that. But if he can't take some responsibility for himself and start looking up, well, then it's unfortunate. So, and thank you for reminding me that it was inside of a confinement facility. And when we say it, we mean the new charges of the assault inside the jail. So, Miss Odell, that, by the way, requires a correction on your SIR 88-1 at the bottom where it says concurrent. The court again continues that sentence. The court adds two $68 state minimum fees, a $130 crime victims' right fund fee, no court costs, no fines, no attorney fees, nothing else. The court's just going to sentence the defendant to the confinement period. Mr. Cole, you are a young man. You need to figure this out and you need to get help. I recognize that you're only 20 years of age, but you've got the criminal history that most adults don't have. And I'm really sorry, but I'm really hoping they can help you do what no one else here can do. It's because no one else here has the resources to help you. I really wish they did.
So that's both counts, 13 to 24.
Yes, so in file 3675, those two counts run concurrent to one another, but consecutive to file 3663. All right, Mr. Hartel, you're going to take out here to your client 2 copies of one document. Mr. Cole's going to place his initials on the first copy. Doing so, neither elect waive any rights. It merely acknowledges your receipt, Mr. Cole, of the other copy. This document tells you that you have the right to appeal the convictions and sentences that this court has issued in both cases. Based upon the plea, any appeal is done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Ms. Odell, even though they're consecutive, does he qualify or can he qualify for boot camp on either one? Oh, wait, I'm sorry. I also forgot to give you the credit. 1 second. Madam Clerk, the credit in 3675. Oh, it's 0 because he was in jail serving a sentence. All right, thank you. Miss Odell, do you recall?
Your Honor,
It says it doesn't.
I'm
Due to potential mental.
I believe he would have to get his mental health
Yeah.
issues resolved and then
Yep.
he may qualify. Yes.
All right. So what I'm highlighting and asking that question is, and Mr. Hartel, make sure you explain it to him, if not now, maybe later, because I know he may not be hearing me very well. If he gets his mental health addressed, which is what I'm trying to do, really, because nothing here is going to work or has worked. If he gets that mental health addressed and he does qualify for boot camp, I will approve it. All right. What we're trying to do is change the direction of this young man's river, and hopefully he'll get some better treatment. And if he does and he qualifies for boot camp, he'll be out faster than if I'd left him here in the jail. All right. That's really my objective, because we do not have the treatment that we need, because we do not have the funding that we need locally as a community and as this court to help this young man. All right, the court has received the judgments here. And Mr. Hartel, you can bring those forward for the appellate rights. Anything else today, Ms. Odell?
No, Your Honor, thank you.
Mr. Ringstrom?
No, Your Honor, thank you.
Thank you. Mr. Hartel?
Nothing else today, no.
All right. Mr. Hartel, again, please make sure you take some time. I trust that you will. But please make sure you take some time, maybe today, to go over and talk to this young man and tell him, hey, Judge Elmore wants you to do the boot camp. So do the, and typically I'd make the person do half part of the sentence. But because they're running consecutive, after he serves the first one, and he'll get his good conduct time added to his time period at the jail. So that'll be 25 days. So he'll have 170 some days of credit. So if he gets his mental health taken care of in case 1, and he can immediately apply for boot camp in case 2, he'll get out in less than a year. Hopefully that makes sense to everybody. At least that's my mindset. All right. Thank you very much. We are adjourned.
Alrighty, folks, hour 3 of TCF Live. I have Dungeon Court on deck ready to go, but before we go there, let's do one more hearing with Judge Stevens.
Yeah.
We have 2 cases. Cause number 24CR559. That's a motion to revoke unadjudicated probation, and a new case 25CR1332. Second degree felony of indecency with a child by sexual contact, and the defendant was on probation in the earlier case 559 for the third degree felony of, looks like,
injury
to a child. Does the defendant waive formal readings of the motion to revoke unadjudicated probation in 559 and the indictment in 1332. Can we proceed in summary?
It is.
Pick them up numerically. In 24 CL 559. There's a motion to revoke unadjudicated probation. In each of these cases, the defendant waives formal readings of the charging instruments, and we can proceed in summary.
Yes, sir.
Mr. Andrews, raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
Lower your hand. You are Kendall DeJuan Andrews? Yeah. In this motion to revoke unadjudicated probation 24 CR 559, in summary, this alleges that on March 27th, 2024, in this criminal district court of Jefferson County, Texas, you were placed on deferred or unadjudicated probation for 10 years for the offense of injury to a child younger than 15 years of age. You understand? Is all of that true and correct, sir?
Yes, sir.
What are we pleading truth?
Yeah.
One is the indecency, which is represented by the new indictment 25 CR 1332.
Yes, sir.
Allegation one states you committed the offense of indecency with a child by sexual contact on or about May 9th, 2025 in Jefferson County, Texas, which is a violation of condition one of your deferred or unadjudicated probation order, which states that you shall not commit any offense against the laws of Texas, the state, or any other state or of the United States. Is allegation one true and correct?
Yes, sir.
Are you pleading true and correct voluntarily and because it is true,
Yes,
as it is alleged? Correct? It's true as it is alleged?
Yes, sir.
Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that's enough to grant a motion to revoke probation
Yes, sir.
by a preponderance of the evidence or greater? Your probation can now be revoked. You can be found guilty and sentenced up to the full range of punishment for this third degree felony, which is no less than 2, no more than 10 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes, sir.
There is an agreement that's been reached in this case where you would be pleading true, found guilty, sentenced to 10 years in prison. This would run concurrently with the sentence that is going to be assessed and a plea of guilty you're going to be entering into in the next case, this second degree felony of indecency with a child, 25 CR 1332. Is all of that true and correct?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Hold on, everybody. I'm going to try to erase something off the pad and using this stylus that anything can happen when the stylus touches this pad.
But here's not just on me.
All right, I am going to follow this agreement. Anything to add before I make findings here on this case?
No, yeah.
Anything you want to say, Mr. Andrews?
No, sir.
If not, I'm going to find in this motion to revoke unadjudicated probation 24 CR 1559 that you were placed on probation earlier in this case on March 27th, 2024 in this court. I find you are pleading true to allegation number 1 of this motion to revoke probation, committing the offense of indecency with a child,
Yes, sir.
as we have placed into the record. That is supported by your voluntarily and knowingly made plea of true to that violation, admitting it. That is enough to grant this motion to revoke unadjudicated probation by a preponderance of the evidence or greater. This motion is granted and your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you pleaded guilty to this 3rd-degree felony of injury to a child, causing bodily injury to a child younger than 15 years of age. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at that hearing initially to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of the 3rd-degree felony of injury to a child. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. Do you understand what has happened in this case, sir?
Yes, sir.
We now go to 25 CR 1332. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, sir.
In summary, this indictment, handed up on September of 2025, alleges that on or about May 9th, 2025, in Jefferson County, Texas, you committed the 2nd-degree felony of indecency with a child by sexual conduct, namely touching the genitals of the child, a person younger than 17 years of age. Do you understand what you are charged with here?
Yes, sir.
I believe the child was 10 years of age at the time of this event. Is that correct, everyone? That's what this alleges in the probable cause affidavit.
That would probably be accurate, Judge.
If convicted of this crime, this is a 2nd-degree felony, which means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
It is accurate, Judge.
An agreement has been reached where you would be pleading guilty, found guilty, sentenced to 10 years in prison to run concurrently with the preceding case that you were placed on probation for, was revoked and sentenced to 10 years a few moments ago. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you will have no right of appeal of your case. Do you understand?
Sir.
How do you plead to this 2nd-degree felony of indecency to a child with contact by contact? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1 in this case. Did you sign that document, understand it, discuss it with your attorney?
Yes, sir.
Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence
Okay.
without objection admitted. This states, among other things, you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report this way.
We would, that.
I'm going to follow this agreement. Anything else to add by any party?
No, yeah.
Not, I'm going to find that Kendall Dewan Andrews, Dewan Andrew, am I pronouncing your middle name? Dewan Andrews, you are pleading guilty to the 2nd-degree felony of indecency with a child. Voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 to find you guilty beyond a reasonable doubt. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
I now find you guilty beyond a reasonable doubt of the second-degree felony. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice prison to serve a term of 10 years. And this sentence shall run concurrently with the preceding cause number 24 CR 559, the probation of the injury to a child for which you were just a few moments ago revoked off of your probation, found guilty, and sentenced to 10 years. These will run concurrently. Also, this indecency with a child is an offense under the state of Texas laws, which require you to register as a sex offender under the sex offender registration program in Chapter 62 of the Texas Code of Criminal Procedure. Do you understand you have responsibilities to comply with that part of the law? Failing to do so is a criminal offense that may result in prosecution. If you move to another state that has similar reporting requirements for sex offenders, you must register in that state. Failing to register would result with you being charged with a criminal offense. I'm looking at a document that looks as though you've signed this and your attorney has acknowledged that he's discussed this with you. Is all of that true and correct?
Yes, sir.
All right. This is made a part of the record as well. It's called Sex Offender Registration Admonishments. And you have continuing duties under this law to perform responsibly. Do you understand what has happened today, sir?
Yes, sir.
God bless you. Just 1 second, please. You're 22 years of age now, correct, sir? Is that right?
Yes, sir.
Okay. One thing that this court is just going to add as, I guess, an additional footnote on this, each of these children were 10 years of age at the time they were assaulted, sexually assaulted by the defendant. These were your children too, correct? No, they were, you foster the child's mother you were married to or had a relationship with?
No, sir.
Okay. What was the relationship these children were to you?
Cousins.
I'm sorry?
Cousins.
They were part of your family though. But they were family members, right?
Yes,
they weren't just strangers, they were family members.
Yes, sir.
Okay. And you are 22 years of age, correct?
Yes, sir.
You were on probation for the injury to a child, which was a sexual assault, of causing bodily injury by touching the anus of the little child. And I read the probable cause, and it's you were you invaded the anus of the innocent child with your finger. And then here, this indecency where the child is touching the genitals of the child. And these are both 10-year-these were both 10-year-old children. There's probably no worse of a crime than the harming of a child and the sexual exploitation of a child. Not just one, you got two here. And this is all too often happening of cases in this courtroom. I don't know what the problem is, but it will be dealt with severely. The state is very vigorous in prosecuting this. There's no one that has any sympathy with someone who harms a child. No one. The children really are almost defenseless when they're 10 years of age, or an adult took on them, come along and assault them. And from what we all know, it's not like they can forget about it. A 10-year-old can remember. I remember when I was far younger than 10 years old of important events that affected us emotionally. So this child isn't just victimized once. I'm sure she will relive this horror maybe most of her life. So you will be victimizing her maybe all the rest of her life. Can you think anything worse than that? No. Well, it will be dealt with severely. The law states it shall. The state's pretty vigorous, and this court will continue to be very aggressive and just. But justice when you harm a child is severely assessed. Do you understand? That is all.
All right, friends, we've reached that point on a Super Friday where it's time to lighten the mood just a little bit. If you are new around here, you are about to experience TCF's guilty pleasure. It is the best, worst court that is out there that we've been able to find. The blood-red carpeting ripped straight from The Shining. The sandstone wall in the background that every now and then you can see shedding just a little bit of bloody tears. The screams, the moans in the background from the undead who continue to walk this dreary, drab place. The lighting that is ripped straight out of the Soviet Cold War era. The printer that never stops running. The prosecuting attorney who is old as the Crypt Keeper himself. The eternal chair of doom sitting to the right. Ladies and gentlemen, we all know that Appalachian justice is best served in a cold, dank basement. Therefore, my friends, I'm proud to present Dungeon Court.
And you had a review hearing. Well, it was actually the 18th. There might have been some confusion about that since I think it might have been told the 19th. That
Yes,
was
Your
actually
Honor.
a holiday.
Yeah, I came over here last Friday and it was closed, and then I had drug court on Monday, and I moved into aftercare, so I wasn't able to come Monday, so that's why I'm here now.
What drug court are you in?
Cabell County.
Okay, Judge Howard?
Yes, sir.
Okay. All right, you still have some community service to do. You've done some, you did 6 hours since your last hearing. So.
She has some to turn in, Your Honor.
Okay.
Appears to be 8 hours.
Okay, I'll cancel any more if it, I don't think it'd been actually issued yet. But if it had been, it should be canceled, and I'll reschedule you. Does it matter if it's Mondays or Fridays?
Well, I have drug court classes on Fridays, so
Mondays are better?
yeah, if possible.
Let's do August the 10th.
That's a Monday. August the 10th will be your next hearing, 9 o'clock.
Thank you, Your Honor.
You are.
State of Ohio versus Shannon Elliott, case number CRB 26349, A and B.
And are you Shannon Elliott?
Yes, sir.
Did you receive a copy of the charges? Okay. And there's two.
Yes, sir.
349 A and B. The A case is consumption of alcohol in a motor vehicle, and it alleges that on May 12th of this year in your own township, you were consuming alcohol in a motor vehicle. That's a 4th degree misdemeanor, maximum penalty is 30 days in jail, $250 fine, and that you had an open container of alcohol in a motor vehicle. That's a minor misdemeanor, maximum penalty is $150 fine.
Yes, sir.
Do you understand the two charges?
Yes, sir.
Do you understand your rights?
Yes, sir.
How do you plead?
Guilty.
Guilty means you're admitting it's true.
Yes.
By doing that, you waive the rights to have a trial in order. You understand that?
I missed my court date because I was in the hospital. I went and got mental health done, and then I'm doing outpatient at OVP. I got put on the Brixadi, I'm doing counseling as well, and I work with Pacira.
Okay. Okay, this is from Athalia, and I've got a report that says May 12th, Truman Roberts and I, which is the Woodyard as the chief, on patrol in village of Athalia, observed a vehicle traveling without registration plates. Stop was initiated, approached the vehicle. It was determined the registration had fallen down inside the rear windshield.
Yes, sir.
Made contact, there was an odor of alcohol coming from inside the vehicle. Female identified as Shannon Elliott, admitted to having alcohol inside the vehicle. Open container was observed. She stated it belonged to her solely. She appeared to be visibly intoxicated. The driver advised himself had been consuming alcohol and that the alcohol belonged to her.
Yes, sir.
Okay, that's it. State take any position on this?
No, Your Honor.
All right. I'll impose a $25 fine on each and 1 court cost.
Okay.
Do you need time to pay?
How much do I owe today?
That'd be $175 total.
I'll pay it.
I'm sorry?
I'll pay it.
You can pay it today?
Yeah.
Okay, see, the clerk is to the right as you get out of the courtroom. Guys, see the clerk, pay your fine and court costs, and you're finished.
All right, thank you, sir. Have a great day.
You too.
State of Ohio versus William Richardson, case number CRB 21846, A and B, CRB 21566.
Okay, these are old cases, 21846. Have been set for a hearing about June the 8th of this year, and it's the last Mr. Richardson did not appear again. You admit that, sir?
Yeah, I was transferring facilities to come down this way from Cleveland.
Okay. You got a report from Southern Hope?
Yeah, I got a guy from here too. His name's Paul. Paul something.
You just started there June 20th.
Monday. Yeah.
The judge might need
I've got one.
Okay, thank you, sir.
Okay, I'll go along with you going to Southern Hope, agree with that. I'll cancel the warrant and set you up for another review.
Thank you, sir.
So let's do it in about a month, maybe a little more. So August 7th will be your next hearing for review at 9 a.m.
Wait.
questions, sir, just do what the treatment is program. They'll make sure you're here for your next hearing.
All right, thanks, man.
Thank you.
Appreciate you, sir. Have a good day.
State of Ohio versus Mark Daniels, case number TRC 192674. Mark Daniels.
Mark Daniels is here. We had a hearing on Thursday, 18th, wasn't here then. He's here now. Do you have an explanation for missing on the 18th?
I didn't know there was no court Friday.
Okay. Can you pay anything on your fines today?
I paid it 2 weeks ago.
You paid on the 12th, I see. Okay, you gotta get your community service done. Set your next hearing for August the 10th. August the 10th, 9 o'clock. Cancel the warrant.
Thank you, sir.
You're welcome.
State of Ohio versus Sandra Curry, case number CRB 26389. Sandra Curry.
Ma'am, are you Sandra L. Curry?
Yes, sir, I am.
Ms. Curry, the state's alleging that at Fayette Township on June 24th, you knowingly caused Chavez Durham to believe you would cause serious physical harm to this person or property. That's aggravated menacing. It's a first-degree misdemeanor. Maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
I think so.
Do you understand the rights defendants have?
Yes,
How do you want to plead to this charge?
not guilty.
Do you want to be considered for a court-appointed lawyer?
I don't think I would qualify.
Okay, so you want some time to hire a lawyer?
Yes.
Okay, let's see what we got in terms of when we set a pretrial. I could, set it on the 13th or any time thereafter in July, so that would be a little over 2 weeks. Do you think that's enough time for you to get a lawyer?
I hope.
Okay, let's set it for July 13th.
Okay, sir, I should have told you this in the beginning. My husband has kidney dialysis on Tuesday, Thursday, and Saturday.
Okay, well, this is a Monday, so.
Okay. Okay.
July 13th will be your next hearing. It'll be a pretrial at 10 o'clock, right back here at this court. I'm going to put down that you will hire a lawyer. And I'm going to let you sign a signature bond. And what that means is you're just going to sign a piece of paper that says, I promise I will come to court when ordered. And as long as you do that, you don't have to post any money. But if you don't show up, you get a warrant, then you have to pay the $1,000 for not showing up.
Okay.
So just show up, you don't have to post any money.
I'm going to see if I have this date correct. July 13th at 10 o'clock.
That's correct.
Okay, thank you.
Not guilty plea is entered for you.
We're going to ask for protection order too.
Okay, I'm going to take it from what I read. It's not a problem for you to stay away from Mr. Durham, correct? You don't live around each other? Or...
I don't know him.
Okay. Well, just stay away. That's going to be part of it. I'm going to urge you not to go around this person.
Okay.
She will have to get fingerprinted. So you'll have to, we're going to give you a form to take to the jail to get fingerprinted. That's something we have to do now on every case.
I'm sorry, would you repeat that, please?
You gotta go to the jail to get fingerprinted.
Okay.
And they're gonna give you a form to take. You don't have to stay there, but you just ring the buzzer, they'll come to the door, let you in, take your fingerprints, and then you can go.
Okay, where is the jail?
Across from the main courthouse in Ironton.
Okay.
Right
And
across
you
the
want me to
street.
do that today?
Well, before you come back to court, you don't have to do it today.
Okay, thank you.
So it's at the sheriff's office.
I know.
Just wait in the lobby, I've got to talk to you.
Okay. Thank you.
You're welcome.
State of Ohio versus Shane Lyons, case number TRD 19-1235, A and B, TRD 19-181, CRA 10-929-930, TRD 10-2070.
And sir, you're Shane Lyons?
Yes, sir.
Okay. These are all old cases, but we'll start with 19-1235. That's an arraignment. And it alleges that on May the 4th of 2019 at 7:35 p.m. in Fayette Township, you were driving under a suspended license. That's an unclassified misdemeanor as filed, maximum penalty 500 hours community service and a $1,000 fine. It's also alleged you had expired plates. That's a minor misdemeanor. Maximum penalty is $150 fine. And it's alleged you failed to appear for an arraignment back in May of 2019. 19-181 is a possession of drugs charge. It's alleged that you had a conviction on that, and you had a review hearing set June the 10th of 2019, that you failed to appear for that. Warrant got issued when you failed to appear. And then the last case is a traffic charge 10-2070. It was also set for a review on June 10th of 2019, and it was on a driving under suspension. There was another charge that was amended. Let's see what it was amended from. It was a left of center, driving under suspension. Originally filed some sort of felony. Possession of drugs. It was amended to a misdemeanor. Attempted possession of drugs had been a felony 5. It was amended to an M1. Attempted possession of drugs. That's why it was up. Did you understand these charges, sir?
Yes, sir.
You understand your rights?
No, yes, sir.
How do you plead to these charges?
I want to just go ahead and plead guilty, Your Honor. I had to go do some time down in Texas, and I came back here a couple years ago. I'm working for a drug treatment facility, and I thought I had been paying on these fines. I had no idea I had these warrants out. I turned myself in when I found out that I did. I have a license now. I got everything straight with Columbus.
Who are you working for?
I work for JFT.
Where's that located?
That's here in South Point.
Okay. What's JOT?
Just for today.
Okay. How long have you worked here?
Over a year and a half.
You're living in South Point then? Or?
I live in Ashland.
Ashland.
Yes, sir.
All right. Well, I applaud you for coming in and trying to get this taken care of. So I'll withdraw the warrants, so you're lucky you didn't get nabbed on a warrant on these, so there've been warrants outstanding for a while.
I know, I'm very grateful for not, as soon as I found out I had it, I came right in.
I want to, support you in your recovery. So what we'll do, we'll just set them up for reviews. And my attitude about this, I think it's the correct attitude. I applaud you getting in recovery, and I want to support you in your recovery, but it didn't wipe the slate clean. It doesn't mean like, well, all the stuff you did while you were addicted doesn't go away.
I
It's
know
still
that, Your
there.
Honor.
It's got to be dealt with.
That's why I'm ready to just face up to it and go ahead and get it over with. I have no problem paying the fines. I've been paying several fines to Columbus, South Point, and Cold Grove. And if I would have known that, I would have came right in. I'm so
Okay,
sorry.
So you can pay here, or you can
Well, I paid $100 to your clerks earlier.
on the website, or?
No, I just paid it cash.
Today, was that today?
Yes, sir.
Okay.
I can come in next week and
I
pay
can see
like
that's
2 or 3.
in the file. Okay, so what I'm gonna do, now I'm gonna give you review hearings, Mondays or Fridays, does it matter what days?
No, sir, it don't matter. If I keep my payment up, do I have to still come in?
Yes, sir.
Okay, yeah.
Periodically?
Friday would probably be better.
Okay. We'll make it the 21st of August, your first one, so I'm giving you almost 2 months before you gotta come back.
Okay.
August 21st at 9 o'clock.
Sounds
Next
good.
review hearing.
Yes, sir.
Once you get these completed, you can quit coming to the hearings, and if you can't pay, if you do community service, you get credit toward your fine, $50 every day you do a community service.
Well, I'm actually working 2 jobs, so I shouldn't have no problem paying.
Okay. August 21st, 9 o'clock is your next hearing. Your warrants are withdrawn.
Thank you, sir.
Yes.
On the 19-12-35 case, that was in the record this morning.
Yes.
Alrighty, friends, that will do it for this week of TCF Live. I hope you all enjoyed the week. We had some good hearings, some hard ones for sure, but isn't that every week here? We'll see you Monday, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you are a channel member. And, of course, we will post videos throughout the weekend, so keep an eye out for that. And go have yourselves a great weekend. The wisdom I leave you with for today comes from Proverbs. He who is slow to anger has great understanding, but he who has hasty temper exalts folly. Chew on that as you go throughout your day. I look forward to seeing you all soon. Thanks for joining me. Take care. God bless.